বলো তুমি, তারপর আমি বলবো।
My lord, may I be permitted to mention a restoration application, my lord?
Restoration, no, inclusion, we will decide.
My lord, for inclusion in.
Hand over the slips.
Oh, okay.
Restoration, we are not immediately incorporating. Please, we have said this. As per the convenience of the court, it will be done. Please,
Okay, grateful.
please hand over the slips. Please mention, if it is a fresh application, matters will appear. Fresh application?
Yes, madam, this is my fresh application, my lord.
Mr. Bhatta,
WPST, it was adjourned with a, to enable the state to implement the ROPA rules in respect of the employee. Malab 6 months time was taken. It was adjourned for a period of 6 months.
by us,
No, by the coordinate bench, other bench.
Application.
Now, it has already been expired, nothing has been done. To WPST, similar matter, let it be.
Madam, may I hand over new application?
the WPS letter now. এটা fresh motion বলছে. No affidavit direction is there.
No. Malab undertaking was given, they will implement. That was not done.
Yes.
My lord, this is the madam new application. Madam, for yes.
Whose order? Our order.
No. This is the order passed by Lord Justice Vishwajit Vasu.
Then review why before us.
No, not review. The application, because my lord,
Appeal you have.
appeal in connection with the appeal.
To give the returnable date.
My lord.
This one is appeal, or it was all.
Just new. Why it has
Because after service of notice.
no, we understand what
Can কোথায়? Can number কোথায়? Madam, can is there, all served to all.
So this is a new application.
New application.
What is the date you have given in the form?
Madam,
যে
form.
date দিয়েছো সেদিনটাই আসবে.
Madam, but earlier, matter
After it appeared.
not appeared.
Fresh application list দিয়ে দিও.
My lord.
This one for the hearing, lordship, it was already appeared and the order has already been passed. It is the case, lordship, the 4 persons already read it. That matter relates to the lordship, they are the staff of the council.
No, what we have done
Kindly, lordship, inclusion in the list.
for hearing.
For hearing, lordship, but that there is also an application also that was also
Wait
not
for
disposed. They are only paying for their retirement benefit, lordship. For that reason, I have already filed one application. That
Application.
application
Yes,
also filed.
application will appear. Application.
But
will
the lordship may please to fix any day, 2 persons already retired,
I was-
they are not getting the return
Yes.
benefit. also.
But I was mentioning page 193, item number 272, listed matter for upgradation.
Milord, fresh motion, Milord. Milord,
Why don't you hand
Milord,
over
matter was lastly, Milord, listed on 21st February, and matter was twice adjourned on my prayer, Milord. Matter was supposed to appear on last week, Milord. Fresh motion, Milord. Milord, recruitment to the post of constable in West Bengal Police.
This motion, if see our system is when the matter appears, most of the matters services are not completed. On the prayer of the petitioner, the matters are adjourned.
Yeah, 2 weeks, Milord, adjourned, Milord, it was due
very
to appear
good.
on last week, Milord.
You have to wait for that because you give the copy. You don't complete service and bring the matter in this. Yes, we
I
can.
do have a similar prayer, but it is a WBCT preferred by the Union of India. They took time 2 weeks ago. The matter has been fixed. Matter has been placed. Directed to be appear in the last week.
It is in
the
the
matter-
motion stage.
Motion stage.
My lord, may I have your lordship's kind leave to mention on matter where hearing has been concluded by your lordships, but it is appearing in the list.
That matter
That recovery matter, the Eastern Railway.
was your other side.
I shall inform him.
Then a notice to.
No, I shall inform, my lord. I shall inform. I undertake to inform.
No, is it in the list?
Yes, 83, but it is not being taken up any day.
Just a moment.
83,
Of the,
today's list,
returnable matters.
Hmm.
Hearing.
for orders.
Yes, 83 followers আছে। So why you are mentioning?
My lord, here on the earlier,
Have some patience. We are altering the positions. We are one day we are taking motions, other day we are taking returnable motion, other day we are taking for orders. This way we have distributed. Please keep a watch on the list. Hopefully it will be.
actually, as per the last order, the hearing has been concluded.
Your lordship, 10
But the
analogous
judgment
matters.
has not been delivered.
Your Lordship, 10 analogous matters were kept for as part heard matters in the 9th of October, Your Lordship. It was,
Part heard with whom? With my brother?
yes, yes, Your Lordship.
Part heard matter?
Part heard matters, Your Lordship.
That would-
Another one is also part heard matter, Your Lordship. Both were to be listed in October and January. They may be taken up 2013 matters, Your Lordship. It will take
এর সাথে একটু কথা বলে দিও না, সে একটু
Just mentioning with notice to the other side, page number 193.
hearing.
Yes, hearing, I am praying for upgradation because I will, my lord, this is a mandamus appeal against a judgment dated 9th of August 2019. My claim for being appointed as a primary teacher in Hooghly District Primary School Council is negated. My contention is it is contrary to the recruitment rules of 2001.
So what, there was direction for exchange of evidence?
Everything complete. Paper book is also complete.
We should wait for.
My lord, I am 53 years old. I am 53 years old. If my appeal is allowed today, I will have service for 7 years.
When was the litigation started?
Litigation started in 2012.
What did the single judge say?
Single judge initially relegated it to the Commissioner of School Education. Reasoned order passed. My lord, I assailed it. In a 2014 writ petition, the judgment was delivered beyond 5 years.
The urgency, Mr.
My lord, the urgency is, my lord, presently I am 53 years old. If my appeal is allowed,
Mention the urgency at the top and hand over this. Yes.
very well.
Item number 269 of the monthly list. Number it is the appeal of the Vishabharati University. But I own before the single bench. Number I'm a teacher, I'm a professor.
Please mention the urgency, hand over this. We shall make an endeavor.
I am not getting salary for last 4 months. But they are not moving the appeal. But the appeal is in the list. Number I have retired.
You are not remediless, Mr. Bhattacharya. You can take appropriate steps. Come to us with an application to that effect. Why you are, if you are not remediless, listen, if the litigation has been commenced at the instance of your other side, sometimes it so happens matter is kept pending. Union of India do not appear. No interim order passed, but tribunal does not proceed since we are in CC. In such circumstances, Mr. Bhattacharya, you know what is to be done. This upgradation, Mr. Bhattacharya, how many people we can accommodate?
But I'm not getting
Please think
salary for
over the
last 4
issue.
months.
Please think over the issue and
Because of
come.
the pendency of the appeal, they are saying, the Vishabharati is saying, our appeal is pending. I will not release salary.
So, Mr. Bhattacharya, you know what is to be done. Bolo.
May I lordship's indulgence matter with notice to other side. Lordship, with regard to item number 162 of the monthly combined list, my lord, I'm praying upgradation because of one reason, my lord. Because I was recommended for employment, my lord, by the railways because I have already
Please mention the urgency, hand over this.
then I will, lordship allows me to make a slip and I will hand over. At present, I don't have that.
Please mention the urgency on the notice which you have served and hand over this.
Grateful, my
Yes.
My lord, I am mentioning WBCD matter that was heard by your lordship on 17 November 2021. But I am suffering from nerve disease. That operation will be done in the month of April. Kindly take up this matter and kindly give me fixed date and time. Otherwise, it will be very difficult for after the operation.
You are the petitioner.
No, I am advocate on record. I am for the petitioner.
You are for the petitioner.
Petitioner.
So it is a WPST matter.
A WPC.
Oh,
WPCT.
WPCT.
Yes, my lord.
So you have lost before the tribunal.
Yes.
You have this matter was heard.
Heard by your lordship on for few minutes on 17 November 2021.
What did we say?
Said that lordship
File
said,
your affidavit.
yes, lordship
file
said that
your-
it is I heard only for few matters. So I am to
Please
again
mention the urgency at the top of your notice and hand over this link.
urgency on the application.
Please mention the urgency, hand over this.
I can show the OPD consultation by
Sir,
doctor.
it is your, please mention, we shall get it. Yes,
Urgency.
My lord, applying for restoration, my lord.
restoration, hand over the slip, but we don't know when it could be. Yes,
I have filed an appeal against the single bench order not for granting interim relief because I was the vice chancellor of the KNU.
what you are mentioning, Mr. Chakraborty?
I'm mentioning that for listing accommodating in the list of the appeal I filed.
It is a hearing matter.
It is here, it is application.
The application will appear. Hand over this thing. Not
My lord, may I be permitted to mention, my lord, one writ application, my lord, which is to be tagged with, my lord, the MAT MAT 638, my lord, the bunch of matters, my lord, that your lordship is hearing.
638 land matters.
My lord, no, my lord, the 2016 panel matters, my lord. My lord, the 2016 panel. My lord, the writ application is to be tagged with that, my lord. Justice Basu, the writ was taken up by Justice Basu, my lord. He ordered that the matter be delisted and tagged.
Remind us when we take it up next day.
Lordship, item number 61 of the monthly list. I am seeking your lordship's 2 minutes time. This matter was appearing continuously in the monthly list.
Give 15 minutes time.
Your lordship, I am seeking only 2 minutes time.
Yes.
This matter was appearing in the monthly list continuously. I mentioned this matter on several occasions. I have given the notice to the Union of India.
What do you want?
Your lordship, kindly give me 2 minutes only. On 11th of January, your lordship has allowed me for inclusion in the list, for inclusion, daily cause list. This matter came before your lordship on hearing on 23rd of February.
Madam, tell us what do you want?
Lordship, I told the petitioner that you cannot appear personally when you are represented by an advocate. But on the last occasion, that is on 23rd of February, the petitioner appeared before your lordship and he told before your lordship that his advocates are doing nothing. I have given the notice to the respondents. Your lordship has allowed the mentioning on the 23rd of February.
Why did you allow your client to come over?
I have told him that you cannot mention this matter personally.
Madam, and this.
I am retired. I want.
This mentioning, which we said your junior was there on the side of your client. He was standing.
No. It was not that matter, your lordship. It was not that matter. It was something else matter.
Then what do you want?
I am wanting to retire from this case, your lordship.
You are wanting to
retire from this case.
Retire from what?
From this case, your lordship.
Keep no objection.
Because now the case is going viral and my friends are asking that you are not doing something for your client. I have every sympathy from the client. And the comments are doing in the viral in the YouTube also. And one of the
invite the court to enter into the dispute cropped up in between you and your client. Don't invite.
It's
your client.
He is present before your honor.
Yes, one day he mentioned this matter in person in spite of the fact that he has engaged an advocate. Now it is in between you and your
I
client.
told him that
Whether
he cannot do so.
You can represent him in court or not, that is your own decision. Now you don't involve.
And he submitted that his advocates were not present on that occasion.
Keep just one no objection and hand over it to him.
Much obliged.
Okay, that's all. Next.
May I have your lordship kind leave to file the appeal without certified copy?
Urgency likhe diye.
Urgency likhe diye.
My lord, one
Listen. What is the matter about? Ask him to wait. Ask him to wait here.
Your lordship, it is a WBCT tribunal matter. The petitioner was
Who is your other side in the matter?
the Shobhan Mukherjee, Mr. Shobhan Mukherjee. He is appearing on behalf of the Union of India.
What had been earlier orders passed in the same?
The matter was not heard, your lordship.
It is a fresh matter.
No, lordship. It was heard before the Honorable Division Bench comprising of Harish Tandon before when his lordship has determination.
You settle it up with your client. You talk with him. Then thereafter, whatever development is there, either you come and tell us, or then the client will take his own.
He has the urgency that his job is only for 2 months. That's why I mentioned this matter regularly.
Job is why for 2 months?
He is going to retire in the month of May 2024. That's why
in the month of
May 2024. Yes, your lordship.
Mention that fact. Yes. Are you engaging hard here as your counsel? Do you want to have the advocate or you do not want to take his hard assistance?
Advocate.
Then why did you come and mention? You do not know these things?
Sorry, sir.
When you keep faith on a learned member of the bar, you come to the court and allege that this person is not appearing before you. Huh?
Sorry, sir.
What do you do? What is your work? Ki kaj kore? You are a teacher?
In the railway.
Huh?
In the railway, your lordship.
Railway, which post you are working?
Senior technician, sir.
So senior technician, you do not know that when you have engaged a lawyer, you should abide by what the lawyer says? Huh?
Excuse me, sir.
Excuse me, sir. Ingreji শিখে গেছে. You don't maintain the dignity of the advocates? You have willingly given him a wakalatnama. When she comes and mentions before us, you allege that my advocate is not coming. You are doing this consciously, that let this go viral. We can again upload this snippet and tell, we can rebuke the advocate concern. What is happening to your profession? Is it a case that she is extracting money from you and is keeping out of the court? Huh? You may, allegation you can make every time you will come. Advocate and the urgency in the list
and
give a notice to your other side and come and tell us on Thursday.
Much obliged, Your Lordship.
Senior technician.
May I have
My lord, a review application, my lord, for inclusion in the list.
Our order.
No, my lord, it's first time appearing.
Review of which order? Order
Yes, my lord.
passed by us.
Yes, my lord.
কি ভুল হয়েছে order?
My
What
lord,
did
I have no much instruction, my lord.
Oh, you have no. Who is your other side? Give a notice.
Other side.
Notice দিয়েছে নাকি? So
Yes,
give
my
a
lord, we have served the notice, my
Where
lord.
is that notice? Sir, we
Give
yes.
notice and then make.
Yes.
My lord, I am praying for inclusion in the daily list, my lord.
Sir,
Please.
we have 1,000 times said, please hand over this list.
May I have your lordship kind leave to file without certified copy?
When was the order passed?
Order was passed on 5th March 2024.
2nd February, 5th March. And today we are on 11th March. You are
Lordship.
so impatient. Why? What is the urgency?
Lordship, interim order over on 15th March 2024. Lordship, kindly
15th March?
2024.
Interim order.
Interim order আমরা দিয়েছি।
No, no, Lordship. Single bench order.
So you are agreed by the interim order? Whose appeal is this? Are you the appellant?
Lordship.
You have preferred the writ petition.
No, Lordship.
Who is your
Lordship.
senior, madam?
You are private respondent or on behalf of the state or
I am for the West Bengal Board of Primary Education, Lordship.
West Bengal Board of one interim order was passed against you. You want to challenge the same.
Challenge the
The
order.
validity of said interim order is up to 25. It is your contention.
Then very good. If they do not take any step, interim order will expire.
On 26 it will expire.
ও বলতে পারছে না। You have a senior.
Lordship.
তাহলে why don't you go through the brief before mentioning? Junior counsel. Whenever a senior asks you, you please take the brief, go through the facts and then mention. All right.
Lordship.
Come ready and mention next Monday. Yes. Dhakur, please stand up.
My lord, this matter is appearing for correction. My lord, page number 6. My lord has passed an order on 5th March 2024. My lord, page number 6, last paragraph is a typographical mistake in a date, my lord.
Page number?
Page number 6, last paragraph, 5th line. It will be 9 June 2006. Instead of it, it has been recorded 9 June 2003.
Oh, Ashok, by reason of a typographical error in the last paragraph at page 6, by reason of typographical error, in the last paragraph of internal page 6 of the order dated 5th March 2024, the date of the representation, date of submission of the representation has been incorporated as 9th quote unquote 9 June 2003, single quote unquote, in place and stead of 9th June, 2006. Last paragraph, last paragraph of internal page 6 of the order dated past, comma. the date of submission of the representation has been incorporated as 9 June 2003 in place and state of 9 June 2006. তারপরে ডিপার্টমেন্ট যেটা বলেন
Item number 2, Your Lordship, Mr. Chattopadhyay is appearing for the petitioners, Mr. Uday Shankar Chattopadhyay. He's engaged in some other courtroom, Mr. Lordship. I'm praying for not this week.
এটা কি আগের দিনও এসেছিল? No. Have you completed service? Service is complete.
Not yet, Lordship.
2 weeks করে দাও. If not complete, service is not complete, complete in the meantime. 2 weeks. Yes, next.
Grateful, Lordship.
Lordship, I beg to appear with the state, my lord. Mr. Ghalib is appearing. He is suffering from fever, Lordship. I'm only praying not to the Lordship.
You don't have fever. Huh? Dekhi file it. You don't have fever. If we pass against you, we will consider.
My lord, kindly, my lord, no, my lord, she's praying for not today, my lord, I do not, my lord. My lord, I am also led by Mr. Roy, my lord. Chakraborty Roy, my lord.
And next Tuesday করে দাও.
But I appear for the respondent, man.
Applying for the petitioner. Not very innocuous order today I am asking for, nothing. That my lord, application under section 17 of the West Bengal Premises Tenancy Act 1997 actually was rejected by the officer, and then against that my lord, we went to tribunal. Tribunal, my lord, kindly come to this order of the tribunal.
You are appearing for whom?
For my lord, respondent numbers 1 to 3.
Drink this.
1 to 3, my lord.
Service is complete, Mr.
1 to 3, my lord, rain controller is not required to, but they are the
Service complete, sir.
service complete.
But we are the
Yes.
My lord, kindly come to the order impugned, my lord.
Yes, Mr.
My lord, I am asking only, my lord, that you see, before nearly 13 to 14 years, matter was pending before the rent controller, right? Right from 2009, it was pending. Now it was dismissed, my lord, in 2023. Then we filed, my lord, the tribunal application. Now, my lord, the tribunal application, it was taken up on 19th October 2023. My lord, fixed up the next date of hearing on, my lord, 21st June 2024. My lord, it is my lord, the premises is concerned, my lord, the Trinkers restaurant. No, Park Street, that the AP Park Hotel, and at the ground.
Mr. Bandyopadhyay, file a preponement application. If that is rejected, we will hear, because similar matters are coming, Mr. Bandyopadhyay, with the same problem. If we direct that the
preponement application would be hard after 5 months.
No. Preponement.
No, my lord, nothing is done there. The whole problem is this.
Kept matters pending in there. We have disposed of that. You go and file preponement. If not granted, you come back.
Joseph, the procedure follow করতে সেটাই তো করতে হবে।
Preponement and or early hearing.
Or early hearing, whichever you are. If you file that and come, we can consider. But Mr. Bandyopadhyay, this is this. We keep it next Monday. You think over the matter, come back and tell.
No,
us.
ওদের কি করবি? আমি কিন্তু তার সম্মত থাকতে পারবো না। কি করবি?
Or we can, on his prayer, he can withdraw it. We will say he would be at liberty to approach the tribunal.
কি করবি তোর? ওই তো জজ তো বলছি, জজ তো অন্য ম্যাটারে যা করবে তাই তো হবে।
Preponement or early.
What is the problem?
Permission of final.
No, preponement. No, that.
It has to be served. They will file an objection. It has to be heard, my lord.
Done.
Kindly, just enumerate and dispose of.
Just can I suggest one thing, Miller? Miller, can I suggest one thing, Miller? Just subject to your lord's. Your lordship gives us direction to file an application for
We will record his consent.
But for preponement,
and the application
but
should
only one thing, my lord. My lord will kindly see the order.
That's right. I was
on
not
merit
asking.
of the matter.
No, no,
He
my lord,
said-
I had asked time to file my objection, but that was not opposed.
No, objection, how can I oppose?
When the court gave me time, my lord, till May, my lord, May 2024. My lord, will kindly protect
Very
my
nice.
interest
I
to
don't
that
mind.
effect
On the
also, my lord.
next day, let the matter be heard. No adjournment, nothing. Let on the next day, matter may be heard out by the learned single judge. Tribunal. I am not asking.
My lord, that order can be passed, my lord.
Yes, yes. On the next day, the matter may be heard by the tribunal.
But we will complete the pleadings by the next date, my lord. It can be heard.
Exactly. You are filing the pleading by May.
It is fixed also for hearing on the next date.
Yes,
my lord,
on the
that can
next day, let the matter may be heard and disposed of.
September 2023, you filed the original application. September 2023, most probably. Now it is in the month of March, you have come up seeking a direction for early hearing.
Mr.
Due to
Bandyopadhyay,
the delay caused by the rain controller, you cannot.
But more than 10, 12 years, my lord.
You
I
cannot
understand.
ask a direction, you cannot ask the tribunal that you take out of turn or give priority to my matter.
Well, let
The rain controller caused it.
let the matter be heard and disposed of on that day. That's why I am now asking. I am not asking.
Mr. Bandyopadhyay, what implementation of the order we will make? Kindly consider. You are.
No. Matter may be hard. Matter may be hard and decided. Your lordship can. No, your lordship may not prepone it. I agree with my lord. I may agree, but I can say, my lord, the matter may be hard on that day and decided. Hard and decided. That your lordship always, my lord, fix a specially fixed matter.
6 weeks prior to the next date after supply.
Elections, this date has been fixed on such day that 21st.
21st, 6 weeks, Mr.
6 weeks from October. This has gone.
No, my lord, the order says otherwise, my lord. 6 weeks from the next date of hearing.
By the next.
What?
6
Yes,
weeks
sir.
prior to the next date of
That may be, there may be some, as per the Trade for Liberties granted to contesting respondent want to submit affidavit 6 weeks. 6 weeks prior to the next date after supply of the copy. 6 weeks prior to 21st June 2024. Before that 6 weeks. What I am submitting, you please do not change it. No, not required to change the date. I am not saying. Kindly give a direction on 21st June 2024. Matter may be heard and disposed of. That's why I am praying.
Have you filed affidavit?
My lord, my time is still there, my lord. My time is still there. 6 weeks prior to 21st June, my lord, will be in some
Well,
time
that is
in May.
also not required to be preponed. Let me see.
I'm still within
Let
time.
me be very clear. That should not be. That is not also required to be preponed. On the next day, let the matter be heard and.
Respondent number 1, 2, 3 টা কি?
1, 2, 3 হচ্ছে appear goods.
1, 2, 3 you.
I am appealing for 1, 2, 3, my lord. 4 is the rent controller, but I
Rent
don't
control is
think
not
it's
required.
not
Rent
required.
control is
Yeah, state has not been asked. State was party.
state is not required. State is not necessary party at all.
Mr. Bandyopadhyay, 21st June.
Well, this is a little order, my lord. Nothing more. My lord. It is a little. This is, my lord, for the advancement of justice. Nothing more than that, my lord. This is advancement of justice. If, my lord, would your lordships also fix us the
3 and in control.
your lordships also fixes up so many matters. Let this matter be heard out.
File the opposition. Tell
My
us.
lord, my date, my lord, should
We
be.
understand that. When can you file? Tell us.
But we'll file it within the stipulated date as directed by the court below, my lord, by the tribunal below, my lord. There should be something around 7th or 8th of May, my lord.
I have no objection. Let them do it. What is the rent, you know, in the Park Street with that 8,000 square feet? Rupees 1,900 per month.
You are the.
I am the owner.
Fixation of
Fixation of the. At that time, I have sought for 12,000. That is pending for 12 years.
2009 হয়ে গেছে 23-এ dispose of হয়েছে। এইখানটাই দেরি করে দিচ্ছে অনেক। এই সময় কি কোনো
Malad, kindly do not just catch, do not stay only with a one lacuna of mind.
This petition has been instituted seeking an order upon the learned tribunal to dispose of the original application as expeditiously as possible. Stop. Mr. Bandyopadhyay, learned advocate, appearing
Senior.
Mr. Bandyopadhyay, learned senior, appearing for the petitioner, submits that the petitioner make an application for fixation of fair rent before the rent controller concerned, and rent controller took 14 years to determine the fair rent. Stop. And the order fixes order
Passed by the
rent controller has been assailed
before the
learned tribunal. Stop. Learned tribunal directed the respondent number 2 and 3, say the tenants to submit affidavit, to submit reply.
6 weeks.
Opposition. 6 weeks prior to date of the next date of hearing. Within 6 weeks prior to date of the hearing of the original application has been fixed on June 21, 2020.
Mr. Meghojit Mukherjee, my lord.
Mr. Mukherjee, learned advocate representing respondent number 1, 2, and 3, gives undertaking before submits that the affidavit that the reply shall be filed and served upon the petitioner within the time stipulated by the learned tribunal in the order impugned. Just stop. If such reply is filed, in view thereof, learned tribunal shall dispose of the matter. Okay, on the date. As possible.
Without granting any unnecessary.
Possible on the next date of hearing.
Time. It is expected that the tribunal shall dispose of the original application on the date fixed,
on the date fixed,
or within 6 weeks thereafter, or within 6 weeks thereafter, without granting any unnecessary adjournment to either of the parties. The application dismissed. Yes.
Developers. Great, it's all right. Great.
Thank you.
I'm waiting for.
Mr. Mukherjee, don't make further delay.
No, no,
as you
my lord, no.
explained.
We have time, my lord. We will definitely try and finish it.
We have recorded your statement to that effect.
Developer. I'm waiting only for tomorrow 2 p.m. After this arguing the matter, my lord, I will not be coming up to election. Tomorrow 2 p.m. here, my lords have fixed up that matter. Tomorrow 2 p.m. I will finish it and then.
But tomorrow there is a full court reference.
At 3 o'clock.
So far as I know, before Mr.
3:30. All right, I will finish it by. My lord, I will finish it within 1 hour. 45 minutes to 1 hour. Nothing more than that. And I'm staying in Calcutta only for this reason.
It will be the ultimate matter prior to your
my election. Possibly, my lord. Prior to my election.
Yes.
Deeply obliged, sir. Deeply obliged, grateful.
Grateful, deeply obliged. I, my lord, I vector for the petitioner. But this is, my lord, against my lord, recording of Borga in respect of a land purchased by me. Private no. That is another matter. That your lordship adjourned for 2 weeks.
2 weeks.
So here, my lord, in my land, Borga has been recorded. A private respondents we have served, my lord, sent on my lord 5th of March. I don't see the track report, my lord, showing delivery of my lord copy of the application.
What do you want, Mr.
No, we have challenged an order by which, my lord, the BLLRO as well as my lord, the appellate authority have recorded Borga in my land in respect of the name of the private respondent. My point is very simple, my lord. For recording Borga, my lord, there has to be a finding adjudication on 2 issues. One is that I have given the land to him for cultivation. There has to be a finding. 2 is that there has to be proof of delivery of share of produce. These are 2 sine qua non for recording Borga. And the authorities as well as the court, they have
Hear it on affidavits.
on affidavits. Because none of the issues have been adjudicated only on the basis of a report that he was cultivating.
There is no scope for any interim. Mr.
Let them not give effect. Only thing, order has been passed. So let them not give effect to the order and record the name of this man in the meantime. Because I'm challenging, and your lordship will find there is nothing, my lord, to show that any of the issue have been addressed. None of the issue. And I'm covered by your lordship.
Service filed by the petitioner be kept on record. You have checked up, Mr. Banerjee, service complete.
No, my lord, I submitted, my lord, that 5th of March we have sent. The track report doesn't show it has been received by them. That
Here, it will be kept on record. Upon hearing Mr. Banerjee, learned advocate
engagement by me
appearing for the
delivery of share of produce.
Petitioner and Mr. Siddiqui, learned additional government leader appearing for the state respondents. We are of the opinion that the matter needs to be decided upon exchange of evidence. Accordingly, the respondents would be at liberty to file their affidavit in opposition within 4 weeks. Stop. Reply thereto, if any, be filed within 2 weeks thereafter. Stop. The parties would be at liberty to mention the matter for final hearing after expiry of the period as fixed above towards exchange of evidence. As no one appears on behalf as
sent on 5th of March.
As no one appears, as no one. How many private respondents?
Respondent number 4 to 7, my lord.
Every service tax report have you annexed?
No, 5th of March.
5th of March it has been sent. Today is 11th. 6 days. Should have been served by now, although not updated.
Googly.
As no one appears today on behalf of private respondent numbers 4 to 7, it is 6 weeks, 2 weeks. The petitioner is directed to intimate this order to the said respondents within a week from
today. Instead of 6 weeks, is it possible to not make it 4 weeks, my lord? The point of law is involved, my lord.
Yes, next. Again, they will come. Yes, next.
6 is not similar.
Upon hearing the learned advocate. Upon hearing the learned advocates appearing for the petitioner and the state respondents, and upon considering the materials on record, we are of the opinion. আর ওনাদের নামগুলো দিয়ে দিও কষ্ট. Yes.
Next.
Item number 7, I am for the petitioner, my lord. My contempt application, my lord. Page 17, your lordship's order, my lord.
Yes, Mr. Tapabrata.
Yes, my lord. On the last occasion, I prayed for an accommodation, and lordships had been pleased to grant 4 weeks' time. Now, the last instruction which has come, the file has been sent to pension section for approval. That is the instruction my learned junior has obtained. So, my lord, under such circumstances, I leave it to your lordship, my lord, what your lordship will do. Because
Pension department.
Tell us, Mr. Chakraborty, how long will it take there?
no, it's very difficult. My lord, for me, assuming this office, department to department going on, instructions are not coming in time. But it has, the instruction is that it has gone ultimately to the
As pension department was not a party,
No, pension department party না।
proceeding এর মধ্যে ছিল না, তাই ওদের কোনো
This is this control. No relaxation can be already দেয়া যায় নাকি? দেয়া যায় না?
So they will not comply.
Yeah, they will comply. They are bound to comply. Unless SLP is filed and stay is obtained, they are bound to comply.
When they are not listening, Mr. Chakraborty, then it becomes embarrassing for the court. As you appeared, we said.
I have taken steps to get the instruction. The file, the last occasion I submitted, that red tapeism, this is going from one department to the other. The
So
issue
if
was,
the file has been
may I said, the issue was, since your lordship had been pleased to give relaxation for that period for grant of pension, and that there was a confusion in the department whether this relaxation can at all be obtained or granted in view of a Supreme Court judge. Your lordship had been pleased to consider that judgment and came to a finding, you know, that period has to be counted for the purpose of grant of pension. Now, my lord, now the latest instruction we have got it.
It has been sent to the pension set.
Yes, that
You have a written instruction to that effect.
আছে
That's it. It has been sent to the pension department for DOP, for reply of the DOP.
আর একটা কপি কোথায়
হ্যাঁ আছে স্যার,
দেখি দাও দাও Yes, sir. This is the instruction.
Mr. Chakraborty, actually you have seen most probably the order again and again taking the same point. Which point has been negated by the tribunal, which point has not been accepted by the High Court, again on the same point.
Sir, I am not taking that point at all.
Yeah.
I have come here.
So kindly, if you want to comply, kindly comply as expeditiously as possible, or if you want to challenge the book.
You know, that specific instruction has not also come, that they are going to file SLP.
Because their conduct is not good to the student. He is playing with the court. Since court is ultimately taking decision that this point is wrong, now you take first decision. Again on this point,
All the endeavors you fail. Your lordship can grant exemplary cost and interest. That in execution and consequential relief in a contempt proceeding, your lordship can always.
So who is this person, Mr. Chakraborty? Who is the authority? The senior superintendent of post office.
Yes.
Contempt number 2, my lord.
At present,
section officer claims.
at present,
Department of Pension Welfare.
For final advice and approval in relaxing the, ask this person to appear. When court pass, yet he needs the approval or review from another department, another clerk of the.
that is because the postal department has to send the file to the pension section.
No, it says
No,
it has
for
pensioners welfare cell, it has been said. So read the letter.
For final advice and approval, that is our order, there would be an approving authority. Your letter says so. That I further another approval. You have this. It has been sent for what purpose? For approval. Unless this approval is given, our order has no value.
No, that is not.
Meaning of that.
I submit, subject to what your lordship will say. What your lordship will say. All files of departments regarding pension, these are transmitted to the pension section.
No, as per Mr. Chakraborty, see, the section officer, what he writes, we have This is kindly referred to the above, no, this is referring to the chief, this senior superintendent is not bothered. Section officer writes to this senior superintendent, kindly refer to the above. It is to convey matter has been referred to Department of Pension and Pensioners Welfare for final advice, approval for relaxation. Are who is we to give relaxation? Relaxation we have given.
Yes.
Relaxation inquiry as per rule 88 of you ask this person should be here. Ashok,
Yes.
the present contempt application has been preferred, alleging এই শোনো এই আমাদের কম্পিউটারে কি করে
for us. Here, alleged container, Chief Postmaster General, West Bengal Circle, Senior Superintendent of Post Office, and Director of Accounts, Postal. We are giving an opportunity to appear through online. There are provincial issue rule or sent behind the bar. We are expressing our mind.
as you were appearing, Mr. Chakraborty, you are holding such a responsible post. When this is the attitude of the person concerned towards such a senior member, it is very difficult.
No, I do not appreciate the conduct. I do
Yes, because you came first day and said that either they ought to have preferred SLP or they would comply with you. That is the you are such a senior member. You are and this section officer of a Sangsad Mart will be sitting above. The present contempt application has been preferred alleging violation of an order dated 12 September 2023 passed by this court in the writ petition being WPCT 57 of 2020. Records reveal that the contempt application first came up for hearing on 21st December 2023, and this court directed the petitioner to serve copies of the application upon one alleged contempt, upon the alleged contempt. So, the matter thereafter again appeared on 8th of February 2024. 8th of 2020 when Mr. Chakraborty, learned additional Solicitor General, entered appearance on behalf of the alleged contemnor and prayed for an accommodation to avail necessary instruction. In view of such submissions, the matter was adjourned adjourned till 7th March 2020. Stop. The matter was adjourned. Stop. Today, Mr. Chakraborty, learned. Today, Mr. Chakraborty, stop. Answering our query, Mr. Chakraborty submits that no special leave petition has been preferred against the order dated 12 September 2023.
I will not kindly record as on date. I do not know what they will do. No special leave petition has been preferred as on date today.
আচ্ছা না তাই ওটা কেটে দাও ওই প্যারাটা কি দিয়ে answering our query Answering our query, Mr. Chakraborty submits that no special leave petition against the order order against the order dated 12 September 23 has been preferred till date. Stop. Next one. No instruction is forthcoming as to why till date. Stop. It appears that the alleged contender is very reluctant to comply with the order passed by this court. Stop. Comply with the order passed by this court. In view thereof, we direct the alleged contender to appear before this court online on the returnable date and explain as to why the order of this court has not been complied with for a period of
Whether we direct the alleged contender
to appear online before this court on the returnable date, explaining as to why, to explain as to why the order has not yet been complied, and as to why contempt rules should not be issued against him. Stop. List the matter for further consideration in the daily supplementary list of this court under the same heading on আজকে কত তারিখ 11 তারিখ কবে রাখি হবে
Superintendent of post.
Twenty-seven, 28. Any problem?
27, 28, I shall remain out of station. Because I have-
Mr. Chakraborty, because I think that he will understand your instructions. But if he sits over you also in appeal, then it is
No, that is very
it is an
unfortunate.
insult to the additional solicitor general, and we shall not tolerate this attitude of the superintendent, mere superintendent sitting in appeal over you, huh? And above us, these officers, Mr. Chakraborty, they do not understand with whom they are having the dialogue. You are the additional solicitor general, a highest officer of the Union of India in this court. He appears on behalf of this delinquent
Yes.
person, huh?
To
A
save
senior superintendent,
To save them.
petty government officer thinks he can sit above everybody. Look, he লিখেছো online. List the matter for further consideration under the same heading in the daily supplementary list of this court on 20th March.
No, 27th and 20th March, I shall remain
27, 20, 20.
20, yes,
27th, you said you are in problem.
20th. ঠিক।
We were wanting to give him time so that he can. Anyway, 20 তারিখ রেখে দাও। কোনটা? আচ্ছা তাহলে আরেকটা প্যারাগ্রাফ,
Another copy of this.
আচ্ছা ওইটা আরেকটা answering our query, Mr.
We are taking it on record.
Answering our query, Mr. Chakru, no SLP has been preferred against the said order till date. Right, sir? তারপর কি লিখেছো?
it appears that the alleged contender is
ওইটা পরে দেবে, next paragraph হবে। ওইটা পরে একটা প্যারাগ্রাফ, Mr. Chakraborty has however placed before us a memo dated 6th March 2024 issued by the section officer bracket a pension.
Send a written instruction.
তাই তো বলেছে। ইমেল এসছে তো?
Email.
Wherefrom it appears that the matter has been referred to Department of Pension and Pensioners Welfare for final boldly for final advice stroke approval for relaxation in qualifying service as per rule 88 of CCS rules. TCS pension rules. A copy of the, let a copy of the same be kept on record. By the order dated 21st of Writ Petition. তারপরে ওই পাবে it appears that the alleged contemner, let the same be kept on it. It appears that the alleged contemner is very reluctant to comply with the order of this court.
Let the order be uploaded so that we can communicate it.
Today itself. Today itself.
আমার নামটা দে, আমার নামটাও দিয়ে দে, আমার নামটাও দিয়ে দেবেন কন্টেম্পটি কাজটা।
Yes, next matter.
Lord, I am for the petitioner. My lords. My lords will recall, this is
Yes,
that
Mr. Siddiqui, what happened?
they were supposed to take instructions, my lord, whether they will change order of resumption under 14A, my lord knows.
Have you obtained any instruction?
Instructions, my lord, I believe that though they have given the instructions to Mr. Dhor.
To Mr.
Dhor. Lord, can I come back tomorrow if it comes to your lordship, my lord? Can I come back tomorrow?
My lord, only I cannot
Only
stand
for
in the
my
way.
limited purpose. I'll come back tomorrow, my lord. Lordship, kindly
My lord, then, my lord, let it
Sorry,
retain its
এটাকে
position.
motion heading এ রেখে দাও. It will
same
appear.
position.
Same
No,
position.
not same motion. Because tomorrow we can take another vote. So it may again go down.
Yes, my lord, kindly.
এটাকে তুমি
Because my lord knows, my lord, 100. We are running the factory, my lord, and a constant threat, my lord. যে ওইটা আর কিছু করবে কিনা না, if you can just not মানে চেঞ্জ করে দিয়েছো অলরেডি নিজেদের নামে।
আচ্ছা ডে আফটার টুমরো করে দাও আন্ডার দি হেডিং ওই মোশন ল্যান্ড ট্রাইব্যুনাল করে
Grateful, my lord. I'm extremely grateful.
এই যে এইটা রিটার্নেবল মোশন থেকে ডে আফটার টুমরো. Yes, we are not recording an order, it is under.
Let them not take any steps in the meantime.
They are wasted for some minutes.
Mr. Siddiqui, we are saying that only a notice on WhatsApp was sent, giving a 2 or 3 days times, and hence they could not defend. And you of your own has determined the land which is required to run their factory or mill.
Absolutely, deeply obliged. Survey
Of their, without giving their opportunity. And Mr. Dotto, Advocate General says that in spite of giving notice, they didn't come. On this point, the hearing was stopped. And Dotto said that he would take instruction. You come on that instruction.
Whether those notices were all served up.
Yes, yes. They are saying we have not been able to get any opportunity to defend.
My lord, I'll come back.
And my lord,
Notice was sent over WhatsApp. Thereafter, we is certain that such land is required, such land is not required, and he vested to the state.
Notices were sent by many BLROs of the 4 districts, my lord, I believe.
Yes,
You come to us with that, get the notices. If it has been
really, my lord, our point was, my lord,
without the order.
since it's a
Day
I'll
after
come
tomorrow.
day after tomorrow.
Grateful.
Yes, next.
My lord, I beg to appear on behalf of the petitioner. My lord, with regard to the application, my lord, that is pending, my lord, your lordship on last occasion, Mr. Shirshunno Bandopadhyay and my lord, claim on behalf of my client on the basis of the document issued by the state government. My lord, my client was an employee under the West Bengal Forest Department. Subsequently, he was promoted to the, my lord, Indian Forest Service. Now, my lord, if your lordship kindly sees the Lordship's last order, my lord, passed on 27th of February. My lord, Mr. Bandopadhyay was directed to take instruction, my lord, with regard to the application, my lord, particularly page 32, which forms the basis of my this claim of 5 lakhs rupees at that point of time.
Where is the state?
My lord,
They are answerable, no?
they were to take instructions on last occasion. Mr. Bandopadhyay sought time to take instruction, my lord.
Where is Shishanda Bandobad? You have filed an application.
My lord, that is 7582 of 2018, my lord, for releasing, my lord, the admitted claim, which the state government.
Imagine you know anything about this now.
No, my lord, subject to Lordship's kind sanction, the issue remains, his name was forwarded. President of India, my lord, has given an assent. There was no vacancy. For such reason, he could not take the charge and he did not discharge his duty. For such reason, my lord, we are not in a position to take the charge of him.
Now, he discharged his duties as what?
As IAS, nominated IAS, IFS.
Oh.
For such reason, my lord, we are not in a position.
So why they are claiming this amount? You have not discharged your service?
No, my lord,
that is admitted fact.
That is with regard to, my lord, my main writ petition and my main grievance before the tribunal.
Not
Now,
only that, my lord, he has to cross this, my lord, trouble, that is in respect of the section 21. There is a limitation part. 1996, my lord, 2012, my lord, he has filed.
It was dismissed on limitation?
Limitation ground, the tribunal application. And my lord, but this application, my lord, where I have filed, my lord, in this pending writ petition, my lord, page 32, if your lordship kindly sees.
Then you have not filed any application for seeking condonation of delay.
That was in the court below, my lord, before the tribunal, my lord. But my lord, that is, my lord, that is challenging that, my lord, we have filed this application before your lord, this writ petition before your lordship, my lord.
There's no delay.
No, my lord, that is my content. I will be placing, my lord, 2 judgments when the writ petition.
There was no delay.
There was no delay, my lord. So far in this facts and circumstances where the promotion orders are challenged, my lord, the Limitation Act does not come into play.
Continuing
cause of action. But with regard to the main writ petition, there was no direction of affidavits, my lord. I just remind you.
What did you tell? What was your prayer before the tribunal?
My lord, before the tribunal, my prayer was, my lord, for.
That is a pay.
For about pay fixation of pay, my lord, on promotion and for granting.
You have already retired.
And
Yes,
I have already superannuated. And my lord, for granting of year of allotment.
So let them come with affidavits to that.
My lord, to the main writ application, but to the interim application, my lord, there is an admitted, my lord, contention by the, if your lordship kindly sees.
Union of India, you have not discharged service during that.
No, my lord, so far that is with regard to the main writ petition. But my lord, so far the application is concerned, if your lordship kindly takes a page 32.
Original application.
My lord,
original application.
7582 is the interim application.
Where is the interim application?
7582 of 2018. My lord,
this is of 2018. We will hear both of them together. What is the problem?
My lord, this page 32, my lord, this is the admitted claim that the state government has admitted that yes, my client is entitled to. If your lordship kindly sees page 32. So on the last occasion, what your lordship proposed, my lord, directed the state government to take instructions with regard to disposal of this particular interim application.
Yes, 32 copy for.
That can be considered by, my lord, page 32, my lord, yes, Chief Conservator of Forests. That can be considered. That is not in respect of our case, my lord, that is in respect of the state authorities. Chief Conservator.
So where is his junior is also not here?
I have come to know, my lord, Mr. Orko Nag is the junior. My lord, probably there is a notification, my lord. No. My lord, I have come across a notification that probably at present he is not in the state panel. Maybe that for that reason, my lord.
What, Mr.
Orko Nag, my lord. He is there, my lord. He is there in his resignation, my lord.
But how can we then the writ petition has to be finally heard?
Well, so far the writ petition is concerned, my lord.
If your writ petition has been, your original application has been dismissed, if on the basis of a subsequent memo you are seeking any relief, then we don't have to
let me come back with a fresh notice serving upon the state. My lord, let me serve upon the state. My lord, kindly take it up in the next week. My lord,
Third, Mr.
Because this interim application, if it can be disposed of, my client will get some relief. My lord, so far the main writ application is concerned, my lord, let them file evidence.
Third, Mr. Sur learned advocate appearing for petitioner and Mr. Banerjee learned
Election
advocate appearing for Union of India. Stop. No one appears today on behalf of the state respondents, whose presence is required for adjudication of the present matter. Stop. In view thereof, the petitioner is directed to survey fresh notice upon the respondents upon the
5th of February, your lordship has passed let me carry out the same order, my lord. If on 5th of February 2024, since they were not appearing at that point of time,
you survey fresh notice that respondents were not intimated, only Mr. Banerjee was intimated.
on 5th of February, I have intimated the respondents also, state respondents.
No, we directed you to give the notice to
State authorities as well as Mr. Bandhavai, Mr. Nag, at that point of time.
serve the respondents because he will
My lord,
not
my lord.
directed to
My lord, the state respondents.
upon the respondent numbers, upon the where is Union of India? Union of India is not a party here.
Yes, my lord. They are party,
Yes,
and that's why
yes.
Mr. Author Banerjee.
কোথায়? You have not আচ্ছা good. Press notice upon the respondent numbers 2 to 5 and also upon the learned advocate who entered appearance on their behalf on the last occasion.
My lord, he may not accept it, my lord. Mr. Nag may not accept it. So, my lord, let me serve the state respondent as well as the learned government leader, my lord.
Why, Mr. Shishanno Bandhavadhyay? Give it to him. List the matter for further consideration under the same heading.
এপ্রিল
Email করবো না?
ব্লাড এপ্রিল
Or April.
এপ্রিলে সামনের সপ্তাহে করিস না ভাই পারবো না
List the matter for further consideration under the same heading
বলো তাহলে এপ্রিলে বলো।
বললাম তো
on 9th April.
মাই লর্ড আই এম গেটিং
And to file an evidential service বলে দিয়েছে তো? They could charge also upon the on the earlier and to file an affidavit of service on the returnable. Yes, next.
Actually, may I permit to adjourn for just not today?
But I'm for the petitioner.
I'm private respondent.
Respondent number 2, 3, and 5. I'm applying for respondent number 6 and 7.
Yes, see.
Yes, go on.
The actual mean what the day?
For just day.
Why?
My senior is at
Who is here to?
Gautam Misra.
Huh?
Gautam Misra.
Item number
10. Or day after tomorrow.
10. What is the CAN application? You are also not aware.
Lord, I am for the petitioner, Lord, for disbursements of the family pension. Lord, during pendency of this matter, Lord, the actual nature of the order impugned is this, Lord, my application was rejected. I paid for family pension of my deceased husband together with all other admissible service benefit. Lord, the private respondent, she also claims to be the, Lord, they had relation with the deceased incumbent. So, Lord, the two applications were there before the tribunal, two applications.
Oh, this is reconstruction.
Reconstructed file, Lord.
Now reconstruction.
My Lord, that part was done. Because matter was referred to the mediation center.
This writ petition, any affidavit was filed?
No, Lord. No direction was given. Only, Lord, for the first time, the Honorable Division Bench referred the matter to the mediation center for amicable settlement.
That failed.
Lord, I am submitting something regarding mediation centers matter. Lord, Devjani Mitra was appointed as a mediator. Lord, she tried her best to resolve this problem. Lord, there is a, Lord, I said,
Two wives.
two wives. I am the first wife. Lord, she is not the wife. She has no legal documents, no marriage certificate, nothing else. But according to him, during subsistence.
Let them, when mediation has failed, we have to hear it on merit.
My lord.
Let them use an opposition, we hear the matter, fine.
May I be permitted to mention, submit one thing, admittedly, I am the first wife.
Sir, we have to adjudicate that.
One thing, the family pension, ad hoc family pension for survival of the present petitioners. Some kind of not on any condition.
How they can sanction when the dispute has not been resolved? Dispute has to be resolved first. If not resolved, how they will pay pension?
No, can application has also been served upon us.
Where is the can? We do not know.
That was filed. That was filed on
Made by the
filed on 4th May 2023. Lord.
ঠিক আছে, comma, we are of the view.
আমি দিয়ে দিচ্ছি।
Application আছে।
একটু আপনার নাম।
কি application আছে?
নাম্বারটা লিখে
কার্তিক, কি application?
Application during pendency of this matter, let there be direction from this honorable court to disburse the family pension. Actually, the final relief was sought for, but if the matter is heard finally.
Application টা কি আছে? Reconstruction হয়েছে, ফাইল application তো নেই।
কেন তো না নাম্বার আছে?
না, হ্যাঁ, কেন? Lord, may I pray for the short direction because Lord, the lady is suffering a lot, Lord.
Having regard to the facts and circumstances involved in the case and upon consideration of the submission made by the learned advocate on behalf of the respective parties, we are of the view the writ petition and the application filed in connection therewith should be heard upon exchange of affidavit by the parties. Hence, the respondents are directed to
file their
hence directed respondents are directed to file affidavit in opposition dealing with the amendments made in the writ petition and the application within
4 weeks.
4 weeks, Lordship.
Within 4 weeks from date.
Lord, within 1 week, Lord, I am in urgent.
If any thereto may be filed within 1 week thereafter. Liberty is given to mention the matter for final hearing after expiry of the period stipulated
as fixed above. Yes. Give a copy of that app. Who are you?
So I am for the respondent number 2, 3, and 5. Information commission.
After expiry of this application.
3 weeks and 1 week
had
can
lastly
be
from
possible
us,
so that after 4 weeks
predicament
matter
will
can be.
state
Only 1 week. You are fighting, sir. The matter has been relegated to civil court.
Civil code.
It will take years.
Yes, you give a copy of the
1 week
application.
will not just.
এটা কার ফাইলটা অ্যাপ্লিকেশনটা তাহলে ট্যাগ করিয়ে দাও ইয়েস নেক্সট
Grateful, Lordship.
I'm for the petitioner.
Trustee, I am appearing on behalf of the respondent, the sole respondent.
My lord, challenging the impugned order dated, my lord, 12th May 2023, passed by the Central District Tribunal, my lord. This application has been preferred. The original case, my lord, the applicant in the Central District Tribunal, that is the respondent herein, is a employee under the Railway Authority, my lord. He is a traveling ticket examiner, TTE, my lord. On 6/6/2016, he made a complaint that, my lord, the one EFT book, that is the excess fare ticket book, one first class card and a nameplate was stolen from his possession. And for the loss of that EFT book, and departmental inquiry started, and he was found guilty. And 82,156 rupees was to debit
from his account, my lord. And for that, my lord, 5,477 already debited from his salary. Challenging that, this
5,000?
application,
50,000 already debited. You debited.
5,477 was deducted from his salary. Out of, my lord, his penalty of 82,156.
Lordship, two installments were debited.
Subsequently, another
Two
debited.
installments were debited. Thereafter, I filed the OA and it was stayed.
The order impugned, my lord, if your
Now,
lordship.
whether this part of the order has been given effect to or not, that for refund of rupees such and such pass appropriate
Yes,
order
yes,
of
yes.
refund,
Yes, that order has been given. That order has
you
been.
have acted upon.
No,
No,
I'm
my
not
lord. No. My lord, this appeal is in preferred. My lord, the impugned order starting from page, my lord, if you also kindly come to the impugned order, at relevant page, starting from inner page 6, or rather come to inner page 7, my lord. In the present case, 5.5.
This was decided upon affidavits before the
On
trial?
affidavits.
Huh?
On affidavits.
Have you brought on record affidavits?
Yes, those reply and rejoinder is on
Where
record.
is the affidavit you have brought on record?
Page 47, Lordship.
Have you
That is the
filed any contempt petition?
No, not yet.
My lord, the tribunal impugned passed it order at 5.5. Lordship, you kindly come to the impugned order. In the present case, nothing has come on record that actual excess fare result in financial loss to the respondent authorities. From the impugned order, my lord, inner page 7. And it is also noticeable, 5.6, that the railway authorities, while debiting the aforesaid amount, have ignored the rule position of rule 229. My lord, the impugned order is based upon the rule 229. If you already kindly come to the rule 229 at page.
That has been quoted. Paragraph it has been quoted.
Yes, in the impugned order, it has been quoted at page 67. The entire rule is given. It is a part portion quoted at page 67. It deals with deficiency or loss of ticket. Here, page 67. Deficiency or loss of ticket.
Yes.
Here it is not ticket, my lord. It is excess fare ticket. There is an entirely different. It is ticket and excess fare ticket. Excess fare ticket deals with, my lord, at page 64, annexure P3. Here it is clearly deals. In lieu of dealing with this notification.
Where do you page 64? Yes.
Annexure P3, my lord. Page 64.
Yes. Where is the relevant portion that this rule is applicable?
My lord, page 65, column 6. However, if the inquiry established negligence on the part of the employee's action under major penalty may be initiated, recovery of the loss of revenue as may be ordered by. Well, entire section deals with that. It should be dealt with under this regulation, not under 229. This is the basic.
Why do you say so?
Yes, because one.
What was the charge against him? No deficient, no loss was charged?
No actual loss was there, but he was he lost this ticket, and according to my lord inquiry, he was found guilty, and he accepted the guilt. At page impugned order, page 6, inner page 6, 5.3.
Prior to inquiry, you deducted an amount of 82,000.
That order was passed. Only 10,000 something was deducted by 2 installments.
Where he has admitted, where you are saying?
Yes. At page 6, inner page 6 of the impugn order, my lord, we have carefully examined the joint assignment. The applicant does not dispute that there is a finding on negligence on his part at the bottom, last line, on his part, and departmental proceeding has already been initiated, which cumulated into a minor penalty, etc. So he accepted that he was guilty.
So you imposed a major penalty.
Yes. It is only 82,000 something. It is not, my lord. It is according to the rule, my lord.
Lordship, there is two
It is according
parts.
to rule.
Two parts. One part that I was negligent, so I lost the FT books. Disciplinary proceedings was initiated, and an order penalty was awarded. I made an appeal.
And
Penalty was awarded. I made an appeal, and in appeal, that was reduced. 2 privilege passes were withdrawn. That is the negligent part.
No, negligent part, a disciplinary proceeding was initiated. What happened in that?
Some penalty was awarded.
Penalty was awarded.
I made an appeal.
Acha.
In appeal, penalty was reduced. 2 privilege passes were withdrawn. And I accepted that.
2 privilege passes were withdrawn. Now, as regards this one, what happened?
As regard to the actual loss, an inquiry was initiated.
Same parallel.
Parallel. Whether any actual loss suffered by railway or not.
It is according to, my lord, this regulation. And it's just
And
P.
in that inquiry, it was not proved the EFT foils which were lost from my custody were actually sold and railway suffered loss, monetary loss. It was not proved. So for my negligence, already punishment has been awarded. But in case of actual loss, the railway has failed to prove that any actual loss railway has suffered. But in spite of failure to prove that, they started debiting amount from my salary and presumptive amount.
And
Presumptive.
Presumptive. How much
As
was
I performed duties in the AC coaches, so tickets are average rate of tickets are such and such. So many tickets has been lost. So 81,000 something has been debited. And another thing is that, Lordship.
Now, then what is this application of the rules, what you are saying?
Application of the rules. Yes. Indian Railway Commercial Manual, Volume 1 is applicable, Lordship.
And it's, sir,
Please show us the first order which was passed in the disciplinary proceeding relating to privilege passes.
Annex করেছেন? Not annex.
that is not with us, my lord. But kindly give us some date, my lord. I have already instructed the department to give those documents, and also,
We shall not stay this order.
my lord, give 1 week time. It will be, my lord.
So see, in my original application, it is there, but they have not annexed the annexures.
Stay the order.
Deficiency loss of ticket, where it says only for ticket.
This 82,000 was ascertained to be the amount.
81,000.
Yes. For the
Now
loss
you
of,
started deduction.
yes.
They went to the tribunal.
Yes.
It was stopped. So out of 82,000, you have been able to recover only 10,000
Lordship.
954.
Lordship.
So you refund the amount. Everything will abide by the result of that.
My lord,
Because you are praying for leave to bring materials on record.
Lordship, my point is that my clear point is that order is passed.
Affidavit of service filed by the petitioner be kept on record. Mr. Learned Advocate appearing for the petitioners. Prays for leave to file a supplementary affidavit. Let's a supplementary affidavit be filed within 2 weeks from date with a copy to Mr.
Addressing Prosenjit Borman.
Mr. Borman. Mr. Borman, learned advocate appearing for the
Respondent, the sole respondent.
The respondent. Appearing for the sole respondent. Leaves the matter for further consideration.
সবই তো হয়ে গেছে তো একটা রিজনে এসে গেছে supplementary.
Leaves the matter for further consideration 2 weeks since. Yes.
So another thing, my rejoinder has not been annexed with the main writ petition.
That is also
Rejoinder has not been annexed.
No, only the reply has been annexed.
ডিপার্টমেন্টের কাছে নেই ওটা
Admit করবো। এরকম লেখো in the supplementary affidavit you
also I request to give a copy because department doesn't have that copy. It was not
I will
provided.
supply. Give a copy to him. You supplementary video, you annex that.
Lordship.
Within 2 weeks, you can do it.
Lordship.
Yes, next.
4 weeks, can it be 4 weeks?
4 weeks.
Lordship.
You, Mr. Bormon, hand over a copy to him. Yes. Yes, next. এটা কি দিয়েছে দিয়ে দাও।
You reply return upon.
Item number 12, Mr. Apurva Ghosh appearing for the petition and his family, one of the family members expired. He's out of station. I'm praying for 2 weeks time, Lordship.
2 weeks.
Grateful,
Grateful.
Lordship.
What is the matter, Mr.
This is that matter, my lord, where minor penalty punishment, my lord, was imposed and it was set aside by the learned tribunal without any initiation of the disciplinary proceeding.
Hon'ble.
My lord, the postal department, my lord, staff. And thereafter, my lord, the tribunal set aside the order of interdisciplinary proceeding, and thereafter, my lord, they preferred the appeal, the writ petition.
No, what was after dismissal? What your penalty was? What?
My penalty was, my lord, recovery of, my lord, amount.
Oh, that leave period.
No, my lord, it is recovery of amount. The postal department said that there is a loss of 35 lakhs. So abruptly they said that I will have to give 11 lakhs from my salary. But accordingly, recovery was also started. I came before the tribunal. Tribunal said that without initiation
So
of the
that has been set aside.
it is set aside.
Now
The part already recovered. My lord, now I am also, my lord, retired from the post service.
now
But
the, already recovered was asked to be refunded to you.
yes, I made the application before the tribunal, which is pending now. But because of the writ petition before this honorable court, the writ petition is filed by the Union of India, praying for the order, setting aside the order of the learned tribunal. This matter already Lordship has disposed of, my lord, on the earlier occasion, similar matters. Anyways.
Then you do one thing, it will appear what 11 and 12 or only 12?
Only 11, 12, Lord. Only 12.
So 12 we will keep it under the heading motion and finish it off. All right. It will appear under the heading motion central tribunal. How long?
2 weeks, Lordship.
3 weeks করে দাও 3 weeks since ওই হেডিংটা মনে থাকবে তো নেক্সট
Grateful.
Yes, Mr. Das.
My lord,
yes. For the
this is our application, my lord, against an order, ex parte order, without even being served upon. Mandatory order for completing the promotion process, my lord. My lord, I had on the last date.
Yes, madam.
Mr. Rai had said that he will convince this lordships that the tribunal has the power to pass such ex parte orders.
I tell your lordship, my lord, the case before my land is off.
My lord, my case is mainly on ex parte power of yes.
On that score, my lord, I submitted that if an ex parte order is passed by the tribunal, the remedy is, my lord, file a review. I'll show your lordship the provision for that. Not filing a writ petition before this honorable.
I do.
Well, whether this practice should be, practice should be encouraged or not, that is because of past.
Mr. Rai, you recalling is filed when due to absence it has been.
They call it review, my lord. It is not review under Order 47. Lordship will kindly see the book once, the procedure rules. This my lord, on the earlier occasion tried to, my lord, assist your lordship, but I did not have the provision. May I, my lord, place? 16.
Section.
Rule.
Procedure rules.
Procedure rules.
So how this has affected you, Mr. Dasu?
Yes.
Well, mandatory order. Contempt has already been filed.
To ensure that DPC for the
My lord. Mandatory order. My lord, it is a long drawn out process, my lord. It has been forwarded several times. UPSC is involved. The ministry is involved. A DPC is to be formed. There are another application is pending in the same tribunal. Same issue. Nothing considered, my lord.
The order is...
My case is if the tribunal allows the respondent's application to come up and make submissions, then he can bring this to the matter of the court. Otherwise, he cannot.
Yes, place your case. You do not want to use any opposition to this?
Satisfied. Because here everything is admitted.
Satisfied. Now, Mr. Rai, what form it is appearing?
16.
Any order is passed.
16. I opened the.
Yes, you read which person.
Yes, may I?
Then only remedy shall be open to the person who suffer ex parte order to seek review.
Lordship.
My lord,
He will
ex parte.
not be able to assail that ex parte order before higher court.
My lord, fine distinction. Ex parte order is when the petitioner has been duly served, then he fails to appear. This is a case where we are not even served. No. Obviously, ex parte does not need to be said, described in the.
It is a. The matter has not been solved.
But
in civil, say modern 9 rule 30.
Now, where is the review comes?
Party has not been served. 16.2.
Yes, place it.
Where an application has been heard ex parte against a respondent or such respondent or respondents may apply within 30 days from the date of the order of the tribunal for an order to set it aside. And if such respondent or respondents satisfy the tribunal that the notice was not duly served, or that he or they were prevented by any sufficient cause from appearing when the application was called for hearing, the tribunal may make an order setting aside the ex parte order as against him or them upon such terms as it thinks fit, and shall appoint a day for proceeding with the application.
So where is the bar if he comes to us?
I just beseech your lordship, my lord, because there is an alternative remedy.
Where is the remedy?
Rule 16 is the remedy that they cannot.
Where in spite of service he did not appear.
My lord, lordship will see that. It is, my lord, mentioned that to satisfy the tribunal that the notice was not duly served. This is the case of the petitioner before your lordship. So if it is the case that it is not duly served or even in spite of service did not appear, so the remedy is review.
Now let us hear. Remedy is review where from you are getting?
Because my lord, this is the provision, my lord, they are saying, my lord, ex parte hearing and disposal of the application of the same.
Is to prepare an application for recalling of the order past ex parte.
Yes.
Review another aspect of the matter. Review are asking
why
the
you are
person.
taxing it with review?
Taking
you can say that he ought to have gone before the tribunal to file a recalling application and not to come before this one.
Yes,
but you cannot say that if that had been a case, you have to go and file a review.
Yes, it is a recalling application.
Yes,
there is an alternative remedy.
But in respect of the order which has just accepted the pair since the defendant come. But while passing the ex parte order, anything is determined.
Admitted here. Even in the writ petition, they have come up before your lordship by saying, yes, we are complying with the court's order, but we should have heard.
But it is a promotional process. It is as if it,
Please.
my lord, kindly see the order, my lord.
Yes.
There's a prayer, paragraph 2, my lord. The prayer was an order to issue directing response to act and proceed strictly in accordance with provisions of law. Action of respondent in withholding and holding back the promotional process from post of examiner of trademarks and GI to the post of senior examination of trademark and GI since last 4 years is bad in law and as such should be condemned and or quashed. An order to issue directing the respondent to fairly consider the cases of applications and thereby extend benefit of promotion to the post of senior examination of trademark in favor of the applicants with effect from the date of entitlement and or generally these applications are slowly proceeding that way. Ultimately, if we hadn't challenged this order, next application would have been you give me effect from this date.
What we do?
Sequence is, this is how these applications are proceeded before the tribunal. First application is to consider. Second application, if we do not prefer an appeal. Second application is give me effect from the date of the order or the date of application. Then we will not be left with any defense. We have not challenged the order. My lord.
That is your anticipation.
Well, it is happening. I have come up before this court because of the practice which is being done in many cases, not only just.
Yes, tell us
So these are the, my lord.
What is the wrong with the order? Tell us.
Wrong is the mandatory order, my lord.
Yes, please.
The learned counsel for applicants submits their application is aggrieved by the fact that despite availability of pendency in post of senior examination of trademarks and NGI for a number of years, no DPC has been convened to consider a promotion to candidates who are eligible for the same. He also draws attention to the fact that due to unavailability of department to conduct departmental promotion, the pendency often leads which insists revalidation for the same year of the same year. Learned counsel for the applicant submit the tenure of various posts in department of post of examiner trademark will expire in November 2023. If the posts are not filled up by then, he draws attention to DOPT circular dated 27/8/2021, wherein all ministry departments are asked to ensure strict compliance with instructions for filling up vacancies post in the event of availability of eligible candidate for appointment to the same, and wherein all department ministries were directed to ensure departmental promotions are considered in time to ensure timely promotion of the eligible candidates. He also draws attention to the order of Hon'ble Supreme Court of India in N.R. Banerjee and others, wherein it has been held that the meeting of DPC should be conveyed timely so that promotions are effected timely. Then respondents are directed to consider the representation of the applicant for promotion to the post of senior examiner trademarks within a period of 4 weeks. Consider. Respondents are also directed to ensure the DPC for the is convened urgently and the vacant posts are filled up well before expiry of the tenure of the post 9/11/2000. So it is mandatory. It has to be filled out before 9/11/2023.
And you filed the writ petition in December 2020, after the time was over. And this direction is in consonance with your own guidelines, Mr. Dasgupta.
My lord, one is to do it as soon as possible, do it diligently, do it expeditiously.
Right.
That is one thing. To set dates, my lord,
Court has not said. Court has said date because that is the expiry of the tenure is on that date.
That has no effect. That is as mechanically that is extended. My
Go and argue before the tribunal, Mr. Dasgupta.
Very well.
We shall. Why?
But your lordship will note this practice of passing expertise without the respondent being served. Because, my lord.
No, you go and file a recalling. Contempt is there. Both will be hard.
I have come up before this supervisory jurisdiction challenging this practice of passing orders by tribunals.
That is the discretion of the court. If that is wrongly exercised,
Very well, my lord. Then, my lord, I am relying on a judgment of the Honorable Supreme Court where this issue came up.
Then you argue, then Mr. Dasgupta, we are faced at a juncture.
Now a contempt is pending.
No, if you say that I will argue on merit before this court, irrespective of filing any recalling, we will consider.
My
But if you say that no, I'm withdrawing, I'm go and file recalling, that is enough. If you argue on merits, we have to consider, Mr. Das. It is better for you to go and file a recalling. Why do you want a finding from us, Mr. Das?
my lord, the problem is contempt is pending.
Go and file. They will hear the contempt along with the recalling. Where is the problem? You will say, I have withdrawn. You have a
My lord, if I wait,
difficult path
then my
to
lord,
overcome.
my lord,
You have a difficult path to overcome.
my lord,
Because you could have made that application prior to 9th November. You waited. 9th November expired. You filed the application in
my lord,
December.
that will not, my lord, something, if I delay the matter, my lord, very simple way, if I,
Withdraw করে নাও, recalling. On the prayer of Mr. Dasgupta, learned advocate, on the prayer of Mr. Dasgupta, learned advocate appearing for the petitioners, the writ petition is dismissed as withdrawn with liberty to the petitioners to approach the learned tribunal with liberty to the petitioners to file a recalling application before the learned tribunal. Next.
my lord, will stay the contempt petition at least to the date of extent of date, my lord.
Without any record, how can you go and show we have taken file tomorrow? File. Yes, next. ওইটা ওনাকে ফেরত দিয়ে দাও বইটা। আপনি এদিকে আসুন।
What is my lord? I appear to petitioner, my lord.
I don't know, 14 minutes, I'm appearing on the respondent number 1, my lord.
Who is for the petition?
Petitioner number 1 to 4, but I am
Petitioner.
petitioner. My lord, my lord, the petitioners have challenged, my lord, the petitioners, sorry, your lordships, my lord, challenged, my lord, impugned order, dated, my lord, 26th November 2019. Well, the
Charge sheet quashed.
my lord, tribunal has
You have brought on
Quashed.
record all the documents.
my lord,
Huh?
no order,
Reply rejoinder আছে এখানে?
no, my lord.
তাহলে file your paper book. There is no scope for any interim order.
My lord, may I submit one thing, my lord? The order was of 2019, my lord. And this has been challenged by this application, my lord, which is affirmed only on 15th of December 2023, my lord. There is a gross delay, my lord.
26-hour delay. But why you are aggrieved, sir?
But,
The tribunal has said
yes.
I am complying with High Court order.
No, my lord. No. The order has been challenged here. That those two decisions, one of them, my lord, is already in challenge, you know, WBC number 58 is running in the list, your lordship's list. The Marigal Court, that is Marigal Court first, way number
3465.
946 to 12. The decision has been already challenged before
Which
lordship.
94?
First way number, this or decision passed in the way number.
Oh, acha.
But I will satisfy your lordship. Those two
This
decisions.
way rendered on the basis of the decision of the High Court in WPCT 408.
My lord. Fact situation, my lord, the fact situation is different. My lord. The case was decided on different fact situation. But that will not apply in the particular case. But I will
You
satisfy.
are still working.
My lord,
You are
No,
still
retired.
working.
retired.
Huh?
He retired.
Oh, you have already retired. Pensionary benefits paid to you.
Yes.
I have to take instruction, my lord.
Everything is continuing. Everything is continuing.
Hot issue, my lord.
A short issue will come later. We are questioning a particular thing. Have you retired?
Yes, my lord.
Then this order has already taken, charge sheet has been set aside.
Yes, my lord.
Have you given your full pensionary benefit?
That I have to take instruction, my lord.
Nothing. No prejudice is he has.
So if we set aside this order, he has retired. You will initiate.
No, my lord. Here is a question, my lord. I am challenging the decision making process of the impugned decision.
Oh, after 5 years.
No, my lord.
Huh?
I have stated, my lord, that deal.
Uh-huh.
I have stated, my lord.
What you have stated?
My lord, I have stated.
5 year কি বলবি?
My lord, I have stated.
File
That-
your affidavit. We are not granting any stay. Affidavits were exchanged before the tribunal.
Yes,
Dicta is under
short question, my lord, whether the BSNL CDA rule will be applicable retrospectively or not. Short, very short question is involved here. On that ground, my lord,
Disciplinary proceeding, any punishment was imposed upon you?
No, my lord.
no,
Suspension,
that charge
suspension,
issuance of
What you
the-
appearing for?
I'm respondent number 2.
Who is he? Union of India. Your charge sheet which has been set aside,
Yes, ma'am.
in that disciplinary proceeding prior to final order, the charge sheet was set aside.
my lord.
Yes, ma'am.
Oh,
Issuance of the charge sheet, my lord, they have challenged the issuance of the charge sheet on the ground of applicability of the rule. They
what
said,
was the charge sheet? What was the allegation?
my lord, allegation was not the my lord, acquisition of huge assets, Lord, through corruption, Lord, the
prevention of corruption.
previous under section 13(2), read with 13(1)(e) of the Prevention of Corruption Act. Lord, when a major charge has been, my lord, there, the misconduct committed, and my lord, the value of which, my lord,
The criminal case. What is the fate of that
that's
special
pending.
case?
The CBI, my lord, CBI, Alipur court, my lord, that is pending.
Here, my
My lord,
lord,
my lord, the value of which is,
You
my
have
lord,
got all your
1.5
pensionary
crores.
benefits.
my lord,
You have got all your pensionary benefits.
that I have to take instructions, my lord. Only
No, my lord, everything is okay. He is not suffering any loss or prejudice. Nothing, no alteration of change.
You have released all retained benefit. You have released.
কিছুই জানে না 2015 চার্জশিট
Only one. 7 except one. Look, almost all major benefits have been cleared.
My lord, charge sheet was issued in the year 2015, my lord. And for the time period, my lord, 1st of April 1993 to 3rd of February 2005, my lord. And CDA rules, upon my lord, CDA rules was introduced in the year 2006, my lord.
But
And my lord, on the basis of this CDA rules, charge sheet was issued, my lord, and the time period for placing the charge sheet, my lord, from 1993 and 2005. And this was the main issue of challenge before the Central Administrative Tribunal, my lord. Whether CDA rules will be applicable retrospectively, my lord, and whether the
one matter we are hearing na on that rule 16.
No, my lord. Rule 36, but the charge sheet has been issued under Rule 36 of the BSNL CDA rule.
He was an inductee from Telecom Department.
My lord, my lord, my lord, but not sell, my lord. In fact, I am, my lord, I am
Then
submitting.
come with your affidavit.
My lord, initially, my lord, he
Was
was
the matter hard on
working under.
affidavits?
Those
My
two
lord.
matter are in item number 88 and 91, my lord. 88 and 91.
Very good.
Today's list, my
From
That
same
was
cause of action.
my lord, similar issue, my lord, what have
Similar issue,
Yes,
yes.
my
Same
lord.
cause of
Yes,
action.
my lord.
Whether-
My lord, 90 before 2006, the rule came into effect. That issue was
Yes.
conduct was under
This
consideration.
repeated, this original application was hard on affidavits.
My lord, the OA was
Huh?
OA was hard, my lord. On,
Where is your opposition reply?
my lord, I have not annexed. Lord, I will reply, my lord. I will.
You have not annexed.
My lord, I have not annexed. I have annexed
only the order.
impugned order.
Actually, you file supplementary affidavit bringing the same on record. The petitioner prays for leave to file a supplementary affidavit. Stop. It's a supplementary affidavit filed within 4 weeks from date. with copies to the learned advocates appearing for the respective respondents. Stop, release the matter for further consideration.
Okay.
4 weeks since. Yes, next.
We pay the respondents.
Right, please, Shailesh. Madam, for the petition. My lord, can you kindly recollect, my lord, this matter, my lord, is with respect to, my lord, my prayer for granting voluntary retirement in my favor. So, my lord, the provision in the rule, relevant rule, my lord, postulates that I can make a prayer for voluntary retirement even if less than 3 month time I can give. So, my lord, also, my lord, the rule provides that for this, there has to be a positive assertion by the employer that yes, your prayer for voluntary retirement is denied. So, my lord, that is not done. If that is not done, then, my lord, it will be presumed that I have been given they have acceded to the prayer. Now, my lord, the dispute here arises that while I made the application, they did not deny the prayer, but came in the tribunal by saying that we have passed an order denying the prayer, but it was never communicated. That has been my constant case before every forum. And my lord, on the earlier occasion when this matter was taken up, my lords were of the view that if they can show to your lordship that particular letter denying my prayer is communicated to me, I will be out.
3 months.
Within 3 months, even immediately after they say that it is communicated.
No, what is the rule? Rule is that you can apply even prior to 3 months of expiry of your tenure.
Yes.
So in this case, when was your tenure?
My lord, the general rule is that I can apply for voluntary retirement. I'll have to give 3 months time to the employer.
I see.
My lord, even 3 months is not there, I can make the application for the reasons to be my lord, in my application, and in that case, the authority can concede to my prayer or reject my prayer.
Your retirement date was?
Retirement date. Retirement date कब? कौन सा लेवल? My lord, my 2023 my lord, will be the retirement date.
When did you make the representation?
My lord, my application, the last application for this, my lord, I did, my lord, in 27th of September 2021.
Prior also you made
prior also, my lord, I made the prayer.
So
last I made 27th.
This does not give them three months time.
Yes.
3 months time.
No. In 27th September, what I did, I said that I want voluntary retirement from 1st of October within 4 days. 2021. So, my lord, they did not deny my prayer, but consistently said
the 1st of October is only 3 days there.
Yes, I did that, my lord, because my lord, the rule permitted me to do this. So, my lord, there has been a positive action that ought to have, my lord, come from the employer denying that particular prayer. They did not do, but consistently, my lord, they made the case before the tribunal as well as before this not before this Hon'ble Court, before the tribunal, that they communicated a rejection. So that
within 4 days.
Yes. No. So, my lord, they thereafter, my lord, could not substantiate that particular allegation that they have communicated this. Time and again, my lord, I moved the tribunal. I said that no, there was no communication. But even in spite of that, on the last, the order impugned before this Hon'ble Court, even, my lord, that order was not communicated. It is recorded by the learned tribunal. Yes, it is communicated.
Place the order.
Yes, madam. My lord, the order is, my lord, 15th of December 2023. My lord, from paragraph number 3, my lord, if I can.
No, let us get the facts.
Yes.
Para 3 was you applied on 27 November with effect from 1st October.
Lordship.
And You have not received any letter regarding acceptance. Then applicant filed OA such and such, MA such and such, and CP.
Lordships.
That was disposed of on 9 June 2022.
My lord.
What was the grievance there? That they have
You
not
did not communicate anything to me.
So what did the tribunal say is not yet been communicated. Let
Yes.
the same be communicated so that the challenge it on the evidence till such service, let no coercive action be taken. Liberty to challenge.
Thereafter,
In reply to this original submitted his same, however, at the same was rejected by letter of 8th December 2021.
Yes.
On the ground, there is a pending vigilance case. Examine the applicant had submitted the letter dated at But that period was extended by the order passed on 9th June 2020.
Subject to correction, my lord. That is the order, my lord, which is passed, my lord, on the saying that there is an order, it is not communicated. It is communicated. But even in spite of that, my lord,
you accepted the order.
my lord, after this order, I went on making this application that you never have communicated this one.
After this,
I did not prefer any writ petition.
After this, they issued a letter.
Well, after this also, they did not do anything. I once again went before the learned tribunal.
No.
Yes.
That
I
after
tell you,
this
Lord.
order was passed, you preferred contempt.
My lord, yes. In the
Then
contempt,
they communicated you this letter dated 17th of August 2022.
my lord, this was communicated after I filed this instant original application. My lord, in this instant original application, they communicated this 17th of August by saying that we have communicated you 8th of December, but no evidence, my lord, was given. But the tribunal went on saying that yes, it was communicated 8th of December. So this is why on the earlier occasion, my lord was pleased to, my lord, direct my learned senior to produce any document showing communication.
No, this episode was there before the tribunal in the subsequent representation, subsequent application.
Subsequent application, my lord, when I filed this application,
not this earlier one, before the tribunal.
Yes.
They said that we communicated an order on 8th October.
8th of December. 8th December. 8th December 2021.
8 December 2021.
They said that.
Then
tribunal
they
said
issued a further representation on 17th August 2022.
yes.
That is subsequent to the disposal of your earlier.
That is after the initiation of this instant original application. Yes.
Maybe.
But after the disposal of the
December 23.
Yes. So after the disposal, they did not do anything. Once again, I went before the learned tribunal by way of filing this original application. Then they have come up with this.
What did the tribunal say ultimately?
Yes. The tribunal said it was communicated to you without any evidence to that effect. Since it is communicated, all right, if I can take your lordship, my lord, paragraph number 8 of the learned tribunal's order, impugned before your lordship. Internal page 7.
The rejection was communicated within 3 months. Now you are still in service. So what is the wrong, Mr. Roy? with
My
the
lord, subject to lordship correction, my lord, rule 67. I'll be placing.
Let us get the facts properly.
Yes.
Your representation, first representation for voluntary retirement was on
My lord, the first one was, my lord,
27 September 2001.
that is the last one.
Last first we do not know.
Yes.
This is the
Yes.
application under control.
Yes.
27 September 2021.
21.
Seeking voluntary retirement from 1st of October 2021.
My lord.
They, according to them, they rejected the prayer by a letter of 8th December 2021.
My lord.
Your contention was that this letter was never communicated to me. So you approached the tribunal. Tribunal passed an order on 9th of June 2022 negating your contention and saying that even if not communicated, you would be at liberty to give. This order has not been assailed by you.
It is not assailed.
Then, Mr. Roy, how do you come out of
My
the
lord,
result?
if I can place, my lord, 9th of June's order of the learned tribunal once.
কিছু নেই।
My lord, lordship will kindly appreciate there.
বাজে মামলা।
No. My lord, if I can just, please. My lord, if I can take your lordship, my lord, to page number 60. My lord, 59 it starts from.
The order?
Yes, my lord, the order of the learned tribunal. Previous one.
Previous one. Page
My lord,
number 60.
My lord, 59 it starts, 60 is the relevant portion.
Yes.
But at here, my lord, paragraph number 3. May I, my lord, please? At hearing, learned counsel for the respondent would submit that a decision was taken back in November, would be 2021, to reject the prayer of the applicant, namely such and such, for a voluntary retirement on the ground of pendency of a vigilance case against him. Learned counsel for the applicant would submit that said order rejection was never communicated to the applicant within 3 months, and therefore the voluntary retirement should have taken. If an order was marked in the name of Gopal Prasad Singh, such and such. In the event the said order has not yet been communicated to the applicant, let the same be communicated to him so that the applicant may challenge it on the available grounds. Till such service, let no coercive action be taken against the applicant, and the applicant is at liberty to challenge the said order of fresh grounds. So, one of the tribunal, subject to correction, wanted me to get the order of rejection so that I can challenge it on the ground of Rule 67, that if you do not communicate or if you do not pass a rejection order against my application for voluntary retirement, then it is deemed that I am getting this.
Within how much time?
3 months. So, my lord, after passing this order, they did not do anything. Even after contempt, nothing. Then I filed this original application before the learned tribunal. During the pendency of this original application, they have come up with 17th August and also saying that 8th of December.
Page 77. Right?
Yes, my lord. Yes, my lord, that one. So, my lord, I get this after filing this original application.
So, you challenge 7th of August, you have not gone to the tribunal.
My lord,
you came before us.
17th
of August 2022.
My lord, after filing this original application, this has come in my hand. So
filing, yes.
This one.
Oh,
this one.
Miss, this OA number.
This OA number. This has come. By way of filing a MA, I took these things on record before the tribunal, even by saying that let them show a single document that it is communicated to me. Could not. Even in spite of that, tribunal held, no, it was communicated. So this is why on the earlier occasion, my lords were pleased to direct my learned senior to place a single document by showing that it was ever communicated. That was the instruction, my lord. That was my learned senior was supposed to place to your lordship today.
Kindly come to page 77.
Yes.
Place that letter.
Your application for voluntary retirement dated 27 September 2021 under reference was considered by this administration and the same was not agreed due to pending vigilance case against you. This has already been communicated to you via this office letter of even number of 8th of December 2021. Copy enclosed earlier communication is hereby further sent to you for your information.
Further, as per the Honorable Cat such and such, it is again sent to you.
Next page, next page.
My lord, next page is the 8th of December. It is communicated during the, my lord, original application, the pendency of the hearing of the original application. Because my specific case before the learned tribunal was that I was, my lord, trying to get the benefit of Rule 67. Only by showing that it is, if it is not communicated, it is of no consequence. My lord, that, my lord, they could not substantiate. This is my only prayer before your lordship. If it could, they could show that it is communicated, I got no case, my lord.
What was the court's finding on that?
Yes. My lord,
If
internal
it is
page
not communicated, he
7.
cannot have.
Internal page number 7 of the learned tribunal's order, the paragraph number 8. May I, my lord, please? The applicant had made a request seeking voluntary retirement such and such with effect from such and such. However, as per Rule 67 of the rules, the applicant was required to give notice of not less than 3 months in writing to the appointing authority about his desire to retire from service.
Of not less than
3 months.
But you gave it
For 3 days. It is the interpretation of the learned tribunal. This is also not right. This is why I come before this honorable court. I will be placing your lordship Rule 67.
So you can apply 3 days prior to your
any day lesser than 3 months. This is the rule. Malad, thereafter.
Then why it is saying give notice of not less than 3
Malad,
months?
this is the general rule. But the tribunal did not take into account the exception written proviso written in 67. So thereafter, in the instant case, the applicant has given notice of 4 days of the appointing authority about his desire to retire from service. His notice is not therefore in accordance with the provision of the extant rule and cannot be accepted. Further, the respondent had, on receipt of the notice, rejected his request.
Was the proviso?
Yes. So tribunal said it is rejected and it is communicated. Strangely.
All right, you finish it up. Sorry,
I'm sorry, Malad. I'm sorry.
Had on receipt
of the notice rejected his request for voluntary retirement with effect from 1st of October 2021 in view of the pending vigilance case. I do not know, my lord, from where, my lord, the tribunal could
any
get.
vigilance case is against you.
My lord, that was subsequently filed.
After 2021?
No, in 2021 itself. My lord, I will be coming to that.
Now you are still in service.
I am still in service. The rejection.
When are you to retire?
2030. So the rejection of his request was conveyed to the applicant well before the expiry of 3 months as required. The applicant had claimed that in the earlier way filed by this tribunal that he had not received any intimation from the accepting authority about his request for voluntary retirement. And this tribunal has directed the respondent to communicate the same to him in the event the same was not communicated to him earlier. The respondent have thereafter, via their letter dated 17th of August 2022, informed the applicant that they had already communicated the letter dated 8th of December 2021 to him in pursuance to the aforesaid order of the tribunal. To a specific question put by this tribunal during the hearing, the respondent once again confirmed that the letter dated 8th of December 2021 had been delivered to the applicant. I am of the view that applicant's plea that he had not received the letter dated 8th of December 2021 cannot be accepted. In view of the such and such, it is dismissed.
So was the proviso?
My lord. Rule 67, my lord, it is there in the
yes,
writ petition itself. Yes. If I can take your lordship, page number 63, because the quotation is also not right. 63.
Yes, provided.
Yes, my lord. Rule 67. Retirement on completion of 20 years qualifying service. At any time after the railway servant has completed 20 years qualifying service, he may, by giving notice of not less than 3 months in writing to the appointing authority, retire from service. Provided that this sub-rule shall not apply to the railway servant, including the scientist and technical, this proviso is not applicable on me. 2. The notice of voluntary retirement given under sub-rule 1 shall require acceptance by the appointing authority. Provided that where the appointing authority does not refuse to grant the permission for retirement before the expiry of the period specified in the said notice, the retirement shall become effective from the date of expiry of the said period. Now, my lord, my portion.
If they So if they refuse to grant permission before expiry of the period specified in the notice, that is of not less than 3 months.
3 months. No problem with that. My lord, 3A. A railway servant referred to in sub-rule 1 may make a request in writing to the appointing authority to accept notice of voluntary retirement of not less than 3 months, giving reason therefore.
Show your application.
Yes.
Please show your application at this.
Yes. My lord, if I can take your lordship, my lord, to page number 51.
51.
51, my lord. My lord, may I, my lord, please? I'm sorry.
Yes, page 50.
My lord, may I, my lord, please?
Yes.
Sir, I had applied voluntary retirement earlier with a letter under reference 9th of March 2021 due to my health problem, left knee joint and family issues. But it was not accepted in due time. And finally, I have withdrawn the application for voluntary retirement of 25th of June 2021 as my left knee joint pain reduced by that time. Now, again, I'm suffering from the same problem of health and unable to attend the office, for which sick has been reported to the office as per medical doctor advice. I'm suffering from high sugar and heart problem in addition to knee joint pain. This time I'm suffering severely than previous and decided to take voluntary retirement. I have served Metro Railway since last 20 years, 7 months with full satisfaction and devotion to Metro Railway administration. I am hereby tendering my request for voluntary retirement with effect from 1st of October 2021 through this application. It is requested to accept my request of voluntary retirement with effect from 1st of October 2021, considering my severe health problems, so that I shall be highly obliged to you for this kindness. So, my lord, this is my application. So, I made my reasons there. So, my lord, as per the rule, they are supposed to, my lord, deal with these reasons, whether this is, my lord, satisfactory or not. And they are, my lord, under statutory obligation, my lord, to come to a conclusion about my prayer for voluntary retirement. If, my lord, they do not reply to that, it is seemed that they have accepted this. So, my lord, this is why, my lord, time and again, the tribunal, my lord, tried to see the communication, never showed, but on the final date, it just accepted sacrosanct whatever has been said.
অর্ডারে ডেট ছিল না ট্রাইব্যুনালে, যেখানে ট্রাইব্যুনাল যে পাঠিয়েছিল ট্রাইব্যুনাল চেয়ে পাঠিয়েছিল মানে এই মামলা চলাকালীন
হচ্ছে যে গভর্নমেন্ট আর যদি তবে আমাকে রিজেক্ট কিন্তু I would clear.
না আমাদের জানেন
কিছু বলেন সাবমিশন করেছিল তারা কিছু জানা
I am not communicated with that about the inquiry.
Mr. Rai, 67, your argument is that even below 3 months, I am entitled under the
provision.
And if they do not, even if it is below 3 months, an obligation is vested upon them to consider.
Yes.
And they can discharge themselves of that obligation.
By refusing my pay.
Kindly come to the rule again. Yes. The cost of repetition, page 64.
That's sub-rule
3A. This is relating to acceptance prior to shortage of 3 months.
Lordship.
That is one aspect of it.
Yes.
That I will not accept it because it is below 3 months due to ABCD reasons.
Lordship.
But here your rejection was not on that. It was accepted, but rejected finally for vigilance.
My lord, reject, it was, this is my case, it is
Your
not
case,
rejected.
it was not communicated.
Yes, it is not even, the rejection does not make any sense if, my lord, it says the notice of voluntary retirement given under sub-rule 1 shall require acceptance, provided that where the appointing authority does not refuse to grant permission for retirement before the expiry of the period specified. I'm sorry, my lord. My lord, rule 2, sub-rule 2, proviso. The may I, my lord, please? The notice of voluntary retirement given under sub-rule 1 of 3 months. So it is further clarified in 3 that exception can be made. But what is the general rule? Provided that where the appointing authority does not refuse to grant the permission for retirement before the expiry of the period specified in the said notice, the retirement shall become effective from the date of expiry of the said.
That is why you approach the tribunal. Tribunal said that if you have not communicated, you communicate it.
Yes.
They have communicated you.
But so that I can challenge on this particular grounds. They did not communicate even after passing of the tribunal's order. Finally, in this proceeding, my lord, they communicated. By way,
they are communicating an earlier order which was served.
My lord, lordship will one daily order, if I can take your lordship to one daily order of the tribunal. I have annexed. My lord, page number 74.
Yes, Ms. Alam, what do you say? It was communicated.
Lordship, pursuant to the tribunal's order, it is communicated. I've got, but let me file a report, Lordship, bringing in all the facts. Otherwise,
That
this is
exactly what we want.
no, Lordship. I don't think there was a report. It was only instruction.
We didn't call for
let there be an order for a report. I think that will be the best. With the vigilance, everything. I mean, entire sequence is not before your lordships. It's neither before me, Lordship. That would make the picture more clear, I think.
Then you file an
let a report, my lord, we come to your lordship, my lord, because,
whatever it is,
because I am seriously, my lord, facing prejudice, my lord, for the.
If they do not disclose that in the opposition, it goes.
Yes, it goes then.
My lord,
we will record your argument.
The report, my lord, if they can place to your lordship, my lord, that will, my lord, make everything, my lord, evident to your lordship.
Whatever it is, whichever way your lordship.
Because my lord is senior, my lord.
That's it.
My lord, my
lordship, I shall do it do either within a short time.
My lord, since my lord is senior, my lord is praying for the report, my lord, because the petitioner, my lord, is really, my lord.
We will fix a returnable.
Lordship will fix it.
Take it up.
Fix the returnable data.
I shall not. But since it is a report, my lord, that could be subject to your lordship convenience. Since my lord senior friend is insisting on giving the report.
Not on insisting. I was just, whichever way, lordship, I'll give a short time.
Because that is only, my lord, case
so,
of not.
Miss Alam, as you were appearing, we wanted to know that you check up the file with that.
Lordship, let there be a direction. Let there be a direction. I have.
That means, my lord, there is nothing there.
No, it's not that. But let there be a direction. Let there be a direction.
Has been preferred. Yes, when you are coming, tell us.
3 weeks.
Challenging an order dated.
3 weeks. 3 weeks.
Challenging an order dated. Fifteenth of December 2023, passed in the original application being way number 350/1404/2020. Heard Mr. Ryland, advocate appearing for the petitioner, Miss Alam Learned, advocate appearing for the respondents, prays for leave to file an affidavit in opposition to the writ petition. Let such affidavit in opposition be filed within 3 weeks. 3 weeks. Stop reply there to if any be filed within 2 weeks thereafter. Consideration under the same is matter for further consideration as for orders in the daily supplementary list of this court on 16th April.
Grateful.
আছে কত? হচ্ছে না? 11, 18, 25, 1, তাই তো? 3 সপ্তাহে গেল। আর ওদের 2 সপ্তাহ 15। কত কবে বলেছি? 17, 16, 17 করে 17th as per orders.
Grateful.
চলো লক্ষ্মী দিকে এই ল্যাটের মামলা এখানে কেন এসেছে? Sixteen is yours.
Yes, Your Lordship,
You
I'm
had the
appearing.
matter earlier.
Once Your Lordship, you had called the matter. If Your Lordship may recall, this is an application that was filed against an order passed by the West Bengal Land Reforms Tenancy Tribunal, because my company, the petitioner company herein, it has.
Your other side.
Your Lordship, yes, sir. Representations have not been made by the other side, but the copies of the application have been served.
কালকে কি নিয়ে গো আমরা?
Your Lordship may just indulge me for 5 minutes.
Who is your ডাকো দেখি 16টা ডাক। এটাকে ইয়েতে রেখে দিই। উপরে থাকবে তো? কাম
My lord, with Justice Mantha's kind leave, my lord, may I just mention a matter? My lord, this is a appeal, my lord, assigned to your lordship's bench.
Come,
Or
mention before the regular bench. Yes.
obliged, much obliged.
Yes. Not tomorrow. It is on Thursday. We
My
take
lord,
up mention.
my lord.
Yes, call the list.
But I have concluded my submissions. But only one liberty I am seeking. But we have prepared an affidavit to Milord the National Commission's affidavit. But in course of the day, Milord, we'll file it. But it's almost ready.
Given a copy to them.
Yes, we'll get some copy, circulate copies.
All rights are reserved, sir. Which right is not not reserved?
Including rights under 15 and 16.
I believe Mr. Trivedi wants to address first.
Naturally.
No, it is Mr. Sen's turn now. Last day we were told you are not.
And that
Seniority has to be made.
Submitting it since the state government learned DGS said that they preferred an affidavit. A copy is there to be served. Then in that case, my lord, in case my learned senior friend concludes it, my lord will give me one day. Then on that day, I will conclude with
I will not engage your lordships for long because learned advocate general has argued all the points.
No, he has left some points for you.
I'll try and hunt them out.
it has been served on us.
You conclude today?
Yes.
And Mr. Trivedi, you can start your submission today.
Well, Lord, I shall start. As far as my affidavit is concerned.
In the event you consider something in the affidavit that needs to be addressed, indicate to us or to his lordship, if any is in the other division bench, that you need another. You don't. Then we'll deem it as concluded. All right? Please.
Lord, may I say this before I commence, that if I do say anything right, the credit for whatever I submit will go to my junior. Although I take the responsibility for all my submissions. He has done immense amount of hard work, but I must acknowledge the great amount of assistance that he has given me. Lord, I make arguments on behalf of the West Bengal Commission for Backward Classes. Although I've been fathered by the 1993 Act, I'm really the child of paragraph 847 of Indira Sawhney. So, Lord, paragraph 847 of Indira Sawhney defines the contours within which my jurisdiction are embedded. Your lordships have gone through Indira Sawhney innumerable times. Everybody has cited, but I am concerned really about 847. This is at page 756 of the report. 1992, supplementary 3 Supreme Court cases 217 at page 756, paragraph 847. We are of the considered view that there ought to be a permanent body in the nature of a commission or tribunal to which complaints of wrong inclusion or non-inclusion of groups, classes, and sections in the lists of other backward classes can be made. Your Lordship will notice at the very outset
that the Honorable Supreme Court also uses the word list in plural. Lord, I'll come to this aspect a little later. Such body must be empowered to examine complaints of the said nature and pass appropriate orders.
Sorry, you're reading paragraph?
847 of Indira Soni.
Just give us a.
Yes, Lord.
Yes.
We are of the considered view that there ought to be a permanent body in the nature of a commission or tribunal to which complaints of wrong inclusion or non-inclusion of groups, classes, and sections in the lists of other backward classes can be made, over-inclusion, under-inclusion. Such body must be empowered to examine complaints of the said nature and pass appropriate orders. Its advice, opinion should ordinarily be binding upon the government. Where, however, the government does not agree with its recommendation, it must record its reasons therefor. Even if any new class or group is proposed to be included among the other backward classes, such matter must also be referred to the said body in the first instance and action taken on the basis of its recommendation. The body must be composed of experts in the field, both official and non-official, and must be vested with necessary powers to make a proper and effective inquiry. But pausing here for a moment, Your Lordship will have noticed Supreme Court does not call for formation of a body which is to go about ferreting out information of its own. It is only on receipt of complaints, on references, and on persons coming before the commission with complaints. It does not, suo motu of its own, go about fishing out or causing inquiries or assessments or surveys of its own. If I may use the expression, does not act suo motu. And that is also what is in our statute. Nowhere does the Supreme Court give that mandate. No, this is of some importance, but everything is done on the basis of something which comes before it, either by way of a complaint or a reference by the state. It is equally desirable that each state constitutes such a body which step would go a long way in redressing genuine grievances. Such a body can be created under Clause 4 of Article 16 itself, or under Article 16.4 read with Article 340 as a concomitant of the power to identify and specify backward class of citizens in whose favor reservations are to be provided. We direct that such a body be constituted both at the central level and at the level of the states within 4 months from today. They should become immediately operational and be in a position to entertain and examine forthwith, kindly note, Lord, complaints and matters of the nature aforementioned. Aforementioned as in the previous page, Lord. If any received, it should be open to the government of India and the respective state governments to devise the procedure to be followed by such body. The body or bodies so created can also be consulted in the matter of periodic revision of lists of OBCs. As suggested by Chandrachud CJ and Vasant Kumar, there should be periodic revision, etc. So note the stress that applications made before it and references made before it. It is not, if I may use this loose expression, it is not a somebody who pokes around. It's not a interloper going about trying to ferret out, fish out information on its own, trying to send lists of its own from, but it acts on the basis of what comes before it. Its powers are not untrammeled, unfettered by restrictions of jurisdiction. It can only entertain that which comes before it. Lord, 847 led to the 1993 Act. Your Lordship will notice that both the State Act as well as the Central Act are of 1993, but naturally, as what is well known, what Bengal thinks today, the rest of the country thinks later. So our act came in force a month before the Central Act. If your lordship now comes to our statute, the 1993 statute, it's part of that compilation, Lord, which was handed over by the petitioners to your lordships. I'll take your lordship through a few portions of this statute first, Lord, which just the portions which I feel are relevant for my purpose. Lord, the commission, your lordships have got that, Lord? It starts from page 1 of the compilation. 15 March 1993. Your lordship will find that the commission is constituted in terms of section 3 of the statute. It's a creature of the statute. So the entire repository of all its rights, duties, obligations, and functions are confined within the four corners of the statute. It does not have the power to transgress the four corners of the statute or the battery limits which are provided by the jurisdiction created by this statute. Its powers are, again, Lord, confined to chapter 3 of the statute. Your lordship will find that in section 9 of the Act. Now, Lord, so far section 9 of the Act is concerned, there's a lot of hue and cry about the few months of 2010, March 2010 to September 2010. Prior to September 2010, this was the original section 9. In September 2009, section 9 was amended. It was substituted by a fresh section 9. For the purposes of what took place prior to September 2010, Lord, please have a look at page 4, and Lord, to get an idea as to what transpired later, lordships will look at page 8. In fact, Lord, if your lordships come directly to page 8, I may tell your lordships that what was done is that subsections 2 and 3 were added. The original subsection 2 became 1B. So originally it was subsections 1 and 2, it became 9(1)A and 9(1)B, and then 2 and 3 were added. If your lordship please comes to page 8, 9(1)A and 9(1)B is what existed originally when the inclusions took place. And Lord, here we are talking about the inclusions from 1994 to 2010 and the 6 months of 2010. That is, in Lord, 66 inclusions from 1994 to 2010 and the 42 inclusions which took place in 2010. So 9(1)A and 9(1)B, originally 9(1) and 9(2). Now, Lord, please see what are the powers of the commission. The commission shall examine requests for inclusion of any class of citizens as a backward class in the lists, and hear complaints of over-inclusion or under-inclusion of any backward class in such lists, and tender such advice to the state government as it deems appropriate. So either requests or complaints, just as Indira Sawhney directed that it must do. No power of its own. All the inclusions, 66 plus 42, are on the basis of applications made by the communities, as your lordship has seen about 5 or 7 from our affidavit, and the rest.
42 prior to 2010, or
no, 66 originally from 94 to 2010, and between March and September 2010, that is the allegation that 42 came in.
94 to 2000.
And thereafter, after that, another 35. So 66 plus 42 plus 35, 143. So far as the 66 is concerned, that came prior to 2010. The next 42 also came in prior to this Amendment Act coming in force. At the material point of time when the 108 came in, 66 plus 42, 108. Only this portion that I read existed. So the commission had to act only upon the basis of either a complaint or a request for inclusion. It acted on the basis of request for inclusion. There was no complaint, Lord, and I repeat, there was no complaint of over-inclusion. A complaint with regard to over-inclusion could have been made, but none has been made.
At any point of time for that matter.
At any point of time till date. Till date. Till date. Till date.
So according to you, state was free to include those communities without approaching you. Because unless you are approached, you have no jurisdiction.
Lord, so far as Indira Sawhney's paragraph is concerned, that paragraph says when the state wants to include, it must also consult the commission. I've read out that paragraph. If your lordship please comes to that paragraph once more.
Then how do you read this proposition with the wording of the statute? Wants to include.
Yes, and it makes it refers it to me. It's a request for inclusion. It doesn't say who will make the request. It may not be the community. It may be the state government. It may be an individual. It may be a community. It may be an NGO. Lord, please come to Lord, paragraph 847 once more. And please see Lord, placitum G. Even if any new class or group is proposed to be included among the other backward classes, such matter must also be referred to the said body in the first instance and action taken on the basis of its recommendation. As a matter of fact, subsequent inclusions also have been only upon making a reference to the commission. And I have got, Lord, for your lordship's consideration, a compilation of all the subsequent inclusions. All of them.
So pertaining to these 66, there was no, that was not placed by the state.
Lord, I'm on the fact that at all times, right from 94 onwards, when the first inclusion took place till today, there has been no inclusion by the state in the list without taking us into confidence so far as the classification is concerned, so far as inclusion of classes is concerned. I am not on subcategorization. That is a different argument. Subcategorization or subclassification, as Indira Sawhney calls it, is a different argument altogether. There we have no role to play. And I'll come to that, Lord. So far as inclusion of the class is concerned, Indira Sawhney says, and the statute also says, which is why your lordship will find that the amendment in 2010 took care of this lacuna in the statute by putting in subsections 2 and 3. Because it was felt that there was a gap in the statute, it ought to have been put in because Indira Sawhney said so, which is why subsections 2 and 3 were also put in. The commission shall consider any reference from the state government regarding inclusion of any class of citizens as a backward class in the lists or deletion of any backward classes therefrom. Commission shall on request from the state government examine social and educational conditions and problems incidental thereto of any class, etc. The mandate of Indira Sawhney said inclusion also, consultation is required. The section expressly did not contain it. But as a matter of fact and as a matter of policy, inclusions in the list have been done upon consultation right till date, Lord, and I have a compilation.
Need for the amendment,
Lord, so that there is no ambiguity, Lord. It's a I would submit, Lord, it's a clarificatory amendment.
9 as it's stood,
It's good enough.
which is
Was good enough.
1A. The commission shall examine requests for inclusion of any class of citizens.
Lord, that would have been good enough. This is a clarificatory amendment.
For what purpose? Why was there a need for clarification?
Lord,
You don't legislate for the fun of it.
Lord, to obviate any ambiguity in the clarification, Lord.
What was the ambiguity at all?
Lord, what my Lord Justice Chakraborty was pleased to ask me. Exactly that, Lord. My answer was the request can come from anybody. It can come from an NGO, from the community itself, from the state.
Prior to the amendment, again from a class deprived NGO, whatever.
Anybody can come with a
including
request.
the state government.
Including the state government.
Why was the need for this amendment? Is what we are asking.
Lord, the need, as I respectfully
As
submit,
you
is a
You're not the
clarification.
legislator. You are
No,
a
no.
body.
Absolutely, Lord. I am the creature of this statute. I act on the basis of the powers conferred by this statute.
The need for this amendment.
Lord, so far as the need for the amendment is concerned, is not, Lord, an answer, Lord, I am to give you a lordship, but my understanding is that it was clarificatory to ensure that there was no ambiguity at all, no gaps in the legislation. Lord, the ambiguity would be in the understanding and the comprehension to be given to section 9.1 and 9.2 as it originally stood.
If you don't understand something, can a legislation help you to understand and educate you?
Lord, this, Lord,
or anybody, but you or the state or anybody for that.
now this, Lord, absolutely obliterates any chance of any mistake or any confusion for all times to come. As a matter of practice, the reports will show that consultation took place for adding in the lists. Now, Lord, even subsequently, I don't need to shortly. Your Lordship will find even subsequently all the subsequent inclusions which have been upon consultation, post, which are not challenged, which are not subject matter of challenge. 2015 onwards.
2015 on. We are not, that's not
This is not under challenge, but it's being done and being complied with. So, Lord, this is my first submission. Now, Lord, as your Lordships were pleased to see, the direction, the mandate of Indira Sawhney was both on the central and the state. Both center and the state. Similar directions. The National Commissions Act is at page 25 of this compilation.
I suppose what we find is the difference in the language between 9.1a and 9.2. 9.1a says the commission shall examine requests. Right?
Yes, Lord.
And 9.2 says
consider.
Shall consider any reference. There is some difference in language there.
The difference to the 847 is lower.
One is a case of you examine a request. State, individuals, deprived class, NGOs, whatever. All and sundry. And 2 says the commission shall consider any reference. Any class is citizen backward of a deletion. All right. Now,
the expression reference has come from paragraph 847 because that paragraph uses the expression shall be referred. Shall be referred.
Very well, please tell me.
Now, Lord, if your Lordship is pleased to take the National Commissions Act, also of 1993, this became redundant after the Constitution Amendment. But if your Lordship kindly sees what it was, your Lordship will find that the definition of lists in page 25 of the compilation, Lord, section 2C, it's the same definition of lists. And if your Lordship please takes section 9, Your Lordship will find that there's similar power as with the State Commission, exactly similar ones. But very importantly, Section 10 of both acts are similar. And I lay some stress on this because by reason of Section 10, I would like to argue with your Lordships that both the Central Commission and the State Commissions had not only the authority but the obligation to make an independent assessment of whether a community should be added in as a class or not. And merely because something has come to me, I do not automatically accept. And merely because the State Commission has referred a particular class to the National Commission, there's no automatic inclusion. There must be independent application of mind in both the fora. That's because the powers of the civil court are there in Section 10 of both the statutes. Now, this really became unnecessary after the Constitutional Amendment, when we find, my lord, the National Commission for Backward Classes came in by way of 338B in 2018. Not that it makes much difference, because the Constitution itself in 338B subclause 8 contained the same powers, or gave the same powers to the National Commission, that is the powers of a civil court. Your Lordships, kindly take the Constitution for a moment. If your Lordships are pleased to take 338 capital B, if your Lordship please takes, this is the amendment brought in in 2018 by the 102nd Amendment. Strange, my lord, that in 74 years we have 106 amendments. Leads one to the concept of the ship of Theseus, whether it's the same constitution or it's a new constitution altogether. So even except the basic structure, it's possibly a new constitution. Lord, if your Lordship please takes B5, I'm sorry, not 338B5, it shall be the duty of the Commission, A, to investigate and monitor all matters relating to safeguards provided for the socially and educationally backward classes. Your Lordship will find A, B, C, D. A, B, C. The three subsections give exhaustive powers with regard to investigation, monitoring, with regard to advice. And now this leads us to D, which is very important. The National Commission is to present to the President annually and at such other times as the Commission may deem fit reports upon the working of these safeguards as in ABC. E, to make in such reports the recommendations as to the measures that should be taken, please ignore the union, should be taken by the state for the effective implementation of those safeguards and other measures to the protection, welfare, and socio-economic development of the socially and educationally backward classes. So there is a constitutional duty on the National Commission to report to the President if it finds any drawbacks, any infirmities, any lacuna in our functioning. Lord, from the affidavit filed by the National Commission, your Lordship will find that there is not a single report which has been filed by them and presented to the President, pointing out any infirmity in our functioning with regard to any of the classes that we have incorporated in the lists. Not a single report was presented to the President in all these years from 1994 till date, which is a constitutional duty under Part 3 of the Constitution. So manifestly, the National Commission too does not have any difference of opinion or any misgivings or any complaints or objections with regard to our functioning, the classifications that we have made, the incorporations of different communities that we have made as classes at any point of time till date.
Act constituted the National Commission.
Yes, both national and us. Same year, 1 month this way, that way.
Now, you said that with the coming into effect of this 2018
18.
amendment,
Yes, ma'am.
what was your statement to that effect?
The National Commission Act stood repealed because it was no longer necessary. All the provisions are brought in here. If your Lordship comes back to that.
Stood repealed?
Yes, yes. If your Lordship please comes to that compilation,
Yes.
your Lordship will find that they have annexed the repealing act.
Oh, I see.
If your Lordship please takes page 30 of the compilation.
Oh, repeal act.
Yes.
Yes.
Now, Lord, this apart, please come to clause 7 of 338B. Where any such report or part thereof relates to any matter with which any state government is concerned, a copy of such report shall be forwarded to the state government, which shall cause it to be laid before the legislature of the state along with the memorandum explaining the action taken or proposed to be taken on the recommendations relating to the state and the reasons for the non-acceptance, if any of such recommendations. No such recommendations. No such reports. Nothing has come down. Your Lordship will find in clause 8 powers of a civil court. Lord, the proviso to clause 9 makes it clear that the clause does not apply to 342A(3), which is the power of the state to make its own list. Now, if your Lordships please come to Article 342 capital A. capital A1 is the power to make the central list of OBCs. 342A1, 342 capital A1, creation of the central lists. And 342 capital A3 is the power for the state to prepare and maintain its own lists. (342A1 and 3). 3 is the state's power, 1 is the center's power. remember that in 1992, Lord, the central government, Lord, basing itself on the Mandal Commission recommendations, Lord, issued the impugned office memorandum, the subject matter of Indira Sawhney. So, Lord, in 1994, if I may take it to be the beginning point of the entire subject matter of the proceedings of your lordship, there were or there are, in fact, 3 lists insofar as West Bengal is concerned. The state list made out by the state government under the taking recommendations of the commission under 1993 Act. That's the first list. The second list is a central list made under the Central 1993 Act, subsumed subsequently by the constitutional amendment. And thirdly, the recommendations of the Mandal Commission.
When are you talking about?
I'm talking of the period 1994 onwards. Mandal Commission's recommendations are static, they are cast in stone because they have not taken notice of the subsequent inclusions. That comes to an end in early 90s, 1992. But the later ones are they are developing over a period of time. They are free flowing subsequent.
It was subject matter of challenge for the
Supreme Court.
Indira Sawhney.
Yes, Lord.
Mandal Commission reports were questioned.
Yes, but Mandal Commission's recommendations are on record in the judgment itself, and they are accepted. They are accepted, and your lordship will find the list here. If your lordship takes the compilation, page 42 of the compilation prepared by the writ petitioners, your lordship will find the list which has been made by the Mandal Commission insofar as West Bengal is concerned. Page 42 of the compilation filed by the petitioners. This is the Mandal Commission's list. So, in effect, we have 3 lists. Mandal Commission's list, as I said, is cast in stone because there are no further additions. But so far as central list is concerned and state lists are concerned, these are evolving with inclusions. Now, Lord, what is challenged with your lordship, if your lordship may permit me to just put it in this fashion, are lists in 3 stages. There are essentially 66 inclusions in the whole period between 94 and 2010. 66.
Not subject matter.
No. I'm saying it's in 3 stages. 66 there. The challenge is 42 in 2010 and 35 later. So, Lord, the exercise, Lord, which I would like to carry out with your lordships is to see of the challenged classes, has the National Commission, while preparing its central list, accepted any of them as partaking such character as to fall within 15.4 and 16.4? Because as I submitted before your lordship, they have not filed any report challenging our list, but they've prepared their own lists with powers of on a civil court. When a recommendation, when any list recommendation is made to them, or a reference made to them, or an application made before them, they have to independently apply their mind and accept or reject.
They have mechanically included the list that you have.
Lord, they cannot now stand up before lordship and say we have mechanically done so. The statute earlier and now the constitution mandates them to independently apply their mind as a civil court would do. So they cannot be heard to say that, oh, we just acted mechanically. They may have done so in practice. In law, they cannot make that submission. They cannot today say that we acted on the basis of whatever.
Can you demonstrate that they, in fact, conducted any
That's for them. That's for them to demonstrate. The law says that they have to.
Aware of any independent? Would you?
No, I'm not.
Have been aware.
As the commission, I'm not required to be aware, and I can't be aware because I am only making recommendations for the state government. I have nothing to do with what the National Commission is doing.
And they have not told you.
They have not told me.
We have made an independent survey. We are going.
They were not required to get back to us. We are not acting on their instructions. They are not acting on our instructions.
That under 338 7 and 338, they could have.
They could have, yes, absolutely right. They could have. They could have. Certainly they could have. And they could have even pointed out infirmities in our functioning by tabling such a report before the president.
Did any of the committees or commissions appointed by the central government ever involved you, whether it's Sachar or Rangnath Mishra or any commission?
Lord Rangnath Mishra predates Mandal.
No, there was a Rangnath commission.
Yes, Lord.
Rangnath Mishra does not. So, Mandal, that's right. Rangnath Mishra predates.
And Sachar came in 2006.
And Mandal came in
1992, 1993.
Sir, then I think Rangnath Mishra was after that.
Lord, I just check it up.
Rangnath Mishra was after that.
Achha. Lord, I just check it up.
You can come back. Please continue.
Yes. Now, Lord, the point.
The commission issue already placed in the parliament 1990.
Rangnath Mishra.
No, the Mandal Commission.
Mandal Commission. Rangnath Mishra.
After the block application, the Supreme Court direction in 1993.
Yes. When was the Rangnath Mishra Commission report submitted? Because the Chief Minister's announcement was based on Rangnath Mishra's, referred to Rangnath Mishra's findings. The 10% reservation has to be given to the Muslim government. That is in 2010.
2004.
No, the announcement by the Chief Minister.
Constituted in
There is
2004.
reference to Rangnath Mishra. See if you see the newspaper report. Be that as it may. Please carry on, Mr. Senator.
Lord, Lord, we've tried to compile a tabulation. It's a little colorful, but to help us to appreciate what the position is on facts. We've tried to make it as correct as possible. If there is any mistake, it's an oversight. Now, Lord, Lordship will find the pink are the impugned classes. Since there has been a subsequent subcategorization or subclassification, we've shown it as A and B, but our job is only so far as classification is concerned. The Lordship will find on the left-hand side, there is a blue legend, which relates to the recommendations made by the Mandal Commission. Some of them are in blue. And if your Lordship takes the last column, these are the ones which have been enlisted by the National Commission itself. Enlisted by the State Commission, enlisted by the National Commission. Say, for example, Lord, serial number 1, Abdal. Your Lordship will find it has been enlisted by the Central Commission. It is enlisted by us. This is not under challenge. No. It is under challenge, shown by pink. Now, Lord, I've tried to make a list of how many are the classes which have been challenged by the writ petitioners, but have not been accepted as backward classes by either National Commission or Mandal Commission. Challenged by the writ petitioners, but not accepted by either Mandal Commission or the Central Commission. So we can say these are the virgin communities which are at large, because no other commission has accepted them, neither Mandal nor the National Commission. The rest, either Mandal or the National Commission, have accepted them to be backward.
Whether the Mandal Commission conducted any specific survey in West Bengal?
I am not aware. I am personally not aware, but I can't say so. But I am not aware.
Is your client aware? I mean, if your client is there?
I have to find out. I have to find out.
You said Mandal Commission constitutes to
If your Lordship takes the first page for clarity of this chart, serial number 2, your Lordship will find is neither part of the Mandal Commission recommendation nor enlisted by the Central Commission. Serial number 2. but is part of the challenge before your lordships. Serial number 2. Likewise, serial number 5.
What is this yellow mark?
The yellow ones are the ones which are not part. Yellow to the English. Yellow. Where is the English? Oh, the yellows are the non-Muslims. We just tried to show the demographic, not required, but just to make the position illustrative.
The yellow is all Muslims. This first page.
Your lordship. No, বিভিন্ন রকম wrong. Your lordship will find the green. Your lordship will find the green is Muslim, very representative color, I must say. The orange are the Hindus, or as my learned friends would prefer it, saffron for their benefit. These things, I think I have the liberty with my learned friend to do all this. And the other ones, the ones which are in yellow, are Buddhists, Christians, etc.
Religion classified to be Muslim, Christian,
whatever.
The religions are concerned, I would rather say they're all Indians. But please ignore the religious. But what I'm on is that so far as the challenge is concerned, a substantial portion of the classes or substantial portion of the communities who have been brought in as backward classes and which is the subject matter of challenge, they have been held to be backward classes by the National Commission also. The classification by the National Commission as socially and educationally backward has not been challenged of these very same communities. The dichotomy or the anomaly that will arise is, let us say, in the worst case scenario, your lordships hold that this one particular community ought not to have been classified as a backward class. He will not be a gentleman from that community will not be a backward class for West Bengal, but in the National Commission's list, for all other purposes, he will be a backward class. My respectful submission is to maintain parity. Let us, for the time being, proceed on the basis that those communities which have been classed as backward by either the National Commission or the Mandal Commission and are part of our lists also be taken away from the consideration by your lordships for the time being. Otherwise, they lead to a great anarchy so far as the persons who are members of these.
Already. One, two, Mr. Sen, there is no need for any political correctness.
No. I'm not on political correctness.
For this reason that
not my
the one of the writ petitions is that you have been favoring one particular religious community, the Muslim community. There is
Lord,
no incorrect, I mean, political or so any linguistic incorrectness.
Lord, there is no allegation that my client has favored anybody. I have considered only those persons who have come before me with representations.
Come to that later. Now, insofar as the second presumption that you want us to proceed with for the sake of your argument, there may be a flaw. The reason is, assuming for the sake of argument that the Mandal Commission as well as the National Commission have held that these very classes are also backward in their list. First things first, there is no evidence before us. On the contrary, there is a substantial indication that the Mandal Commission did not conduct any survey in West Bengal. Number two, the inclusion by the center and consequent justification by the state that, look, center included it, maybe based on us, maybe on our recommendation or on their independent assessment. So we are justified in including it as an argument that has been struck down or refused in the Jat Commission, in the Jat case, the Ram Singh case. Because there it was found, the Jat community was, they said, as a sweep, they're there in UP, they are there in Rajasthan, your Haryana, Punjab. Just because they are there as backward in some states, you cannot declare them as backward as a whole.
Not absolutely right.
So
Because
vice versa also.
Absolutely right.
So that presumption that you want us to proceed
no,
on,
my lord is absolutely right.
I have indicated to the learned advocate general, or we have indicated, sorry, and we indicate to you from your website, we have examined closely each and every one of these communities. The exercise you conducted, the data you have put up on the website. We have found the data, at least the research that you did was inadequate because you have also fixed examples of the reports of your commission given to the state government, to the affidavit in opposition or the petition or whatever it is, in the pleadings that are before us. We have examined that also. So each of these 77 communities, we have examined, we have found prima facie from your website that the analysis may not be adequate. So we are concerned with this, and we will have to deal with this as to whether the exercise conducted by you in surveying and independently coming to a conclusion is what is the issue before us, irrespective of whether they included, the Mandal included, or such are recommended.
Lord, I am not trying to justify because of inclusion of the community anywhere else.
You are just saying that.
Lord, it is very true that a community who is backward in one state would not be backward in another state. It's axiomatic. It can't happen in a country like ours, which is with its diversities. But these are the lists in respect of this state, not in respect of any other state. The National Commission's list that I referred to is a list. The same parameters would have been studied by the National Commission, and we must, at least I must, proceed on the basis that they have applied their mind, they have carried out the independent survey, and they have independently come to the conclusion that these communities are to be earmarked as backward in the state of West Bengal.
Then when there is a question as regards their challenge, as regards their inclusion, we'll deal with it.
There is no challenge regarding their list. Lord, my submission for your lordships to consider is, then everybody is wrong. Is it only the petitioner who is right? The state commission of its own has made its own independent survey and has come to a finding.
We are confined to your
The National Commission has made its own independent survey and has come to a finding. So has the Mandal Commission.
See what is the criteria you have adopted in your survey. This is what we are concerned
what
with.
we have considered is before your lordships. I cannot add a line to it, or I can't subtract from it.
Fair enough. Fair enough.
Now, so far as this is one aspect of the matter. And I would Your Lordship may just note down, since for the purposes of the tabulation that I have prepared, Lordship please comes to page 4. I just indicate to your Lordship the what is the ultimate result of this analysis that we have done. I'm informed that there's one mistake. 74 should be a Muslim, not a Muslim, non-Muslim. But that's not really relevant. What I'm on is, my lord, that the number of list of OBCs recognized by the state of West Bengal is 143. This is 66 plus 42 plus 35. I'm not on the later ones. In the central list, there are 99. And your Lordship may note one figure, that the number of communities which are in our list but are not in the Mandal Commission list, not in the National Commission's list, and are under challenge is 38. This figure your Lordship will not get in this chart here. The number of communities. But what I'll do is, if your Lordship permit me to take the chart back, I'll just indicate the ones which are not in any of the other lists. After the hearing is over, and I just hand it back to your Lordship's officers. It's 38. There are 38 communities which have been classified by the state of West Bengal as backward, but are not in any of the other lists. Same period, not in the other lists.
And they are not, these 35 are not in the
Central or Mandal. 38. 38. Not neither in the center or I'll indicate on the tabulation itself. Complete হয়ে যাচ্ছে এটা এইগুলো থেকেই হয়ে যাচ্ছে তো topic. One further thing that I need to show your lordships is their compilation, page 58. In the tabulation, I've indicated the ones included, and I've said 38 have not been included anywhere else. Insofar as these 38 are concerned, what is the fate before the National Commission that will appear from this chart which they have disclosed? I don't know whether these pages have been shown to your lordship because I missed out some of the hearings. But this 58 gives is their chart as to what is the status of the ones which they are pending before the National Commission. Your lordship will find in most of them, hearing concluded, National Commission decision is awaited in most of these. রেজাল্ট কি ইনক্লুড হয়ে গেছে নোটিফিকেশন
Status of those 38.
38, no, this is 38 plus. 38 is amongst them, the ones which are pending and awaited. Either decision hearing concluded, decision awaited, or pending hearing. But subject to correction by my learned friend, I did not find any rejections of the names which have gone from West Bengal. They may indicate. Lord, they have filed a very voluminous affidavit. If your lordship sees that affidavit, your lordship will find there is no indication of any report having been tabled before the president. And your lordship will find these, so far as I could make out, I may have missed out, relate to pending communities pending, not the ones which are under challenge or which have been listed. Right from...
My lord, the state has filed an affidavit in opposition, may I? Affidavit of service. Service একটাই আছে।
Page 24, right till the end. These relate to various queries they have and hearings which they are conducting insofar as the pending applications are concerned.
This pending list is the one that they have annexed to the compiler.
Lord, I have not been able to match the two. It's not possible to match the two because there are overlappings, Lord. Now, Lord, if I may just two technical points, I won't take more than a moment's time on these two technical points. The first, which I would like to beseech your lordship, is that, Lord, 15 and 16 are part of part 3. All the other articles in part 3 give fundamental rights either to persons or citizens. So far as 15 or 16 is concerned, there's a constitutional mandate which enables the state to make special provisions for backward classes, educational and social, both with regard to their education as well as with regard to promotion services, etc. But once the state makes special provisions in tune with the powers given under 15 and 16, these special provisions get attached to the members of these communities as their fundamental rights. And if one is now to curtail or take away or abrogate their fundamental rights, they have a right to be heard. Because now it is no more a competition or a contest between the state or the commission and the writ petitioners alone, but really fundamental rights which have been conferred by virtue of actions taken by the state. So my respectful submission is, it was obligatory on the part of the writ petitioners to file the writ petitions in representative capacities and issue advertisements materia with Order 1 Rule 8 of the Code.
And what is the other point?
Lord, if I may just add one more line, that what the writ petitioners are now endeavoring to do is to abrogate fundamental rights which are vested in determinable sections of the society. They're not undeterminable classes. The moment, Lord, these are identified as classes, as your lordships have observed, these are homogeneous groups which have like attributes. Unlike a caste where it is in the nature of iron, in nature of an iron frame into which one falls the moment one is born. These are, Lord, homogeneous groups where there are like attributes. Therefore, writ petitions must necessarily ought to have been filed in a representative capacity. Public advertisements ought to have been issued in terms of Order 1 Rule 8, with liberty being given to these classes to come forward and have their say, either for or against. Volume 10, Volume 3. Well, this is my first point. The second point, Lord, is on the maintainability. I am not on adequate remedy. Your lordships have indicated several occasions that this is far too late in the day to go back to adequate alternative remedy. That remedy vested with us at the initial stage. Point was not taken, too late in the day. But on maintainability, for this reason, but if your lordship takes his judgment of 2010, there's a mandate of the Supreme Court. Your lordship will find to frame rules. The lordship is pleased to come to paragraph 181, 2010, volume 3, SCC 402. 2010.
Been placed by the
Yes, Lord. I just want to indicate that, Lord, the rules have been framed. And Lord, Rule 56 of the writ rules, now Lord, stares us in the face.
were going through it very carefully. Rule 56 really does not address the entire gamut and categories of PIL as laid down by the Supreme Court. We will be we will be commenting upon that as regards Rule 56, because the learned Advocate General has made detailed submissions by reference to the subject. When we examined it from our own side, we found Rule 56 slightly inadequate at a particular point. We'll address that.
Look, there are some obvious exceptions, for example, with regard to environment.
Oh, yes.
There cannot be a class of marginalized persons who could be aggrieved by the environment. It concerns us all.
Taking a cue from that.
But there are some obvious exceptions. But Lord, when we are dealing with Lord, violation of fundamental rights, there must be a determined class of people who are aggrieved but are unable to come forward to, and your lordship is assuaging them by way of entertaining PILs. Here, which is that class of persons? Who is aggrieved? The writ petitioner is an advocate. So also in 2010, I don't know. Huh? You know, one.
Fourth one is an NGO.
Yes. And in nowhere in their pleadings they say on whose behalf are they ventilating grievances, which marginalized community, which economically downtrodden community, which socially backward community who has been deprived, and they're trying to ventilate their grievances. This is not in respect of an topic which engulfs us all, where perhaps the exceptions would work.
If the argument that we asked the learned advocate, or what the question we posed to him, if by reason of assuming for the sake of argument, that we find that this classification of 10 classes is incorrect. So you're basically talking in terms of 170 posts, 10 and 7, going to the wrong person, or more importantly, removed from the undeserved category. That is the public at large. This is where we found that the action would impact the state as a whole, the entire population of the state as a whole. Because now you cannot say that the SC, ST, and OBC can at best be 50% reserved, which means they could be, let's say, in any situation, about 25 to 30% of the, let's say 40% of the community of the state, the population of the state. So to remove 17%, let's say, apart from SC, ST, from competition for the rest of the state is something that denigrates the very, the state as a whole, whether it's just employment and the consequences.
Lord, I understand what's falling from your lordship. May I only make this a subset? My argument is limited because I represent the commission. 16.4 is something the state is concerned with.
Exactly. So you're traveling into the domain of the state, you will get answers
now so far as
point of view. So
now so far as
we are concerned with this, Mr. Insofar you are concerned, Mr.
The assessment.
We are concerned with what you did with vis-a-vis the exercise of identifying, and why you say that the subclassification you have no role.
Yes.
These are the two issues we
Yes,
want.
yes, Lord. Now, Lord, so far as the subclassification is concerned,
Which
first,
paragraph you are referring to this?
so far as subclassification is
No, 2000.
Lord, if your lordships may please note, Lord, the direction to frame rules is in paragraph 181. Direction to frame rules is in paragraph 181. Lord, there are two other paragraphs which are important. One is paragraph 40, which says that the marginalized sections who are unable to approach court, it is for them. Lordships, I'm pleased to come to paragraph 40. It's taken from MC Mehta's. The Lordship sees just above class item B. To preserve and protect the fundamental rights of the marginalized sections of the society by judicial innovation. And Lord, paragraph 75. The traditional rule of locus standi is broadened. But the preservation and last two lines, preservation of the fundamental rights of people belonging to the poor and the marginalized sections of the society, they have not been identified in the writ petition. Now, Lord, the next aspect of the matter that I regard to the subclassification, first, Lord, is subclassification permissible? So far as permissibility is concerned, Lord, Indira Sawhney is an answer to that. But if I may just indicate the paragraph numbers, your lordships may have already noted the paragraph numbers because extensive arguments have been made. So far as I could gather, the relevant paragraph numbers are 801 onwards, 801 to 803, 859 subparagraph 5, and 860 subparagraph 5.
801.
801 to 803, But 859, subparagraph 5, and 860, subparagraph 5. If your lordship please comes to paragraph 801, which is at page 729. The question was framed as such. Question number 5 at page 729. Whether backward classes can be further divided into backward and more backward categories.
720.
Page 729, my lord.
Paragraph.
It's question number 5. Your lordship will find Supreme Court has framed the question whether backward classes can be further divided into backward and more backward categories. Specific question frame. I'll not trouble your lordship with 801. Perhaps it may have been placed. 802, please see, my lord. We are of the opinion that there is no constitutional or legal bar to a state categorizing the backward classes as backward and more backward. We are not saying that it ought to be done. We are concerned with the question, if a state makes such a categorization, whether it would be invalid. We think not. Then, Lord, if your lordship please see the middle of the paragraph, tacitum D. It talks of a situation with reference to Andhra Pradesh, but it would be applicable here also. In such a situation, a state may think it advisable to make a categorization even among the other backward classes, so as to ensure that the more backward among the backward classes obtain the benefits intended for them. Where to draw the line and how to effect the subclassification is, however, a matter for the commission and the state, and so long as it is reasonably done, the court may not intervene. And now the questions are answered. 859. Yes, no.
Please reread that seconds where to draw the line.
Yes, Lord.
After that,
Is a matter for the in this connection.
yes, where to draw the line.
Where to draw the line and how to effect the subclassification is, however, a matter for the commission and the state.
And the state.
Lord, commission and the state, insofar as we are concerned, Lord, I being a creature of the statute, my powers are within the four corners of the statute. If the statute permits me to make a subcategorization, I can. If not, my powers are limited.
What we are on, when we were asking the learned advocate general, even in the process of subclassification, the commission is involved. It is another thing completely that the state may not have consulted you on the commission on the subclassification.
State did not consult me. That's a matter of fact. State did not consult me.
But you had initially argued that you had no role to play in.
I have no role to play in subcategorization.
But Indra Sawhney clearly here says that you have a role to play in subclassification as well.
Lord, please.
It is for the commission and the state where to draw the line, right? That is the line between to what extent of subclassification, which also includes the percentages. You have a vital role you had a vital role to play. You have a vital role to play, but unfortunately, the state did not involve you at all.
Lord, my understanding of this portion of Indra Sawhney is that these are the two bodies which can possibly have a role, commission and the state. Please do not read the "and" as a pedantic conjunction. It would mean whichever of the two or both.
Your role.
So far as subcategorization is concerned, I say I don't have a role, and I've taken instructions on this.
You have no role.
So far as subcategorization is concerned, making into A and B or further, subject to further notifications, I don't know. But my instructions are, we are involved in the process of carrying out the survey assessment whether backward communities are to be identified as backward classes. Yes.
And no role. That's
in subcategorization amongst backward and more backward. In A and B. Well, as I understand it, the commission is referred in name and its duties are enjoined by the 93 Act. Subcategorization is a later development. As your lordships have been informed, it was subject matter of challenge, but while it was subject matter of challenge, the 2012 legislation came in, where the state has the sole authority to carry out subcategorization. It nowhere refers to the commission. So far as we are concerned, our powers are only for carrying out the duties in Section 9. Section 9 nowhere talks
If
of.
the state would have referred a case of subclassification to you,
Yes,
what is your opinion? What would you have done?
I could not have
Thrown
done it.
back on the face.
I could not have done it.
Would you have told the state? So you would have told the state, we are not involved in subclassification.
That is a question which is in the realm of conjecture.
So no. It's very true. We want to know your mindset. I mean, what do you think? If the state would have, because we understand clearly.
No, the state has not sent it because it was not required.
As per in the opinion of the state.
In the opinion of the state.
And what is your view?
Our opinion is that our powers and duties are circumscribed by the 93 Act. 93 Act does not give us the power to carry out subcategorization of classes who are communities already classed as backward into A, B, or so on and so forth.
Notwithstanding the observations, not just here, in several other places.
Not with regard to fixing up the segments of 10%, 7%, etc. That is not within our power. Nor fixing up the 100-point roster, which is a challenge to the later writ petition. Which is why, if I say so, there's a short point which your lordships are pleased to point out to me in a lighter vein with regard to the filing of the affidavits. Lordships remember that. And I was a little circumspect as to how could this be done. And when we say there was a spirited challenge, we always end by saying spirited challenge ended by defeat. So I don't say make a spirited challenge to this, but I say this, Lord, that the only place where a joint affidavit was filed is in WPO 1160 of 2013, nowhere else.
Main matter.
In all other writ petitions, separate affidavits have been filed. In WPO 1160 of 2013, the only challenge are to provisions and schedules of the 2012 Act, where we have little and no role to play. The joint affidavit was filed only because the lordship will find in the affidavit, before dealing with the paragraphs, there's a portion.
You have nothing to do with the 2012 Act. Why did you join the affidavit?
We were made a party.
We made a party. So your ears and said.
We were because a portion of the affidavit before the paragraphs which deal with their paragraphs, the denial paragraphs, the portion of the prelude to that portion deals with the steps we have taken.
So you are headed by a retired judge of the High Court.
All along. At different times by different persons.
That you can't join hands with the state.
At different times by different High Court judges.
And you were never advised. You are the one. I mean, you are appointed by them.
No.
You were never advised. You did not bother to advise that. How can you join the state? You are supposed to be at arm's length.
Not so far as the assertions in that affidavit is concerned, there is nothing that is contradictory or in conflict or one goes against the other.
It was ensured that.
In that affidavit.
It was ensured that.
No, that I can't say. Long before the present chairperson came in.
Of course. So who's the current chairperson?
Currently, Justice Ashim Banerjee.
All right. He is not heading the other.
Yes, it's also the Health Commission. I think.
Only joined.
Yes. I think he came in 2016 or 2017 or something. Huh?
Yes.
2017.
Prior to this, I think Justice Molloy was.
Justice Molloy Ganguly. Justice Molloy Ganguly, right? No. Molloy Sengupta. Justice Molloy Sengupta. Justice Molloy Sengupta. Because the minutes record is Justice Molloy Sengupta. Now, Lord, so far as this is concerned, please take paragraph 859, which is at page 766. And subparagraph 5, which is at 767. 859, subparagraph 5 at page 767.
Yes, please.
There is no constitutional bar to classify the backward classes of citizens into backward and more backward categories. And I'd mentioned 860, that is with regard to Article 16. The Lordship will find similar in subparagraph 5 at page 770. Page 770, subparagraph 5, with regard to sub-classifications under Article 16.4. Now, if your Lordship please comes back to the compilation, and please see the definition of lists in the two acts.
Even by a reading of subparagraph 5, you are in the view that commission has no role, Mr.
Your Lordship is talking of 860 or 859?
770.
770,
770.
770, certainly, my lord, we can have no role to play because this is Article 16.4.
And 16.4 has been given direction and efficacy by reason of bringing the commission into force.
You see the difference between the 93 Act and the
Now, if your Lordship please comes back to the 93 Act for a moment, and what is our role? Now, so far as the 93 Act and the 2012 Acts are concerned, Lord, there was an observation from the bench that perhaps there's they operate in a similar or a like field. But if your Lordships permit me to draw an analogy of a similar situation, I would draw an analogy between the Representation of People's Act. There are two acts, 1950 Act and 1951 Act. Both operate, but in complementary fields. One complements the other. The Lordship, as a Representation People's Act, are here. Lord, I flag marked my book for your Lordship's convenience. Your Lordship takes the preamble and of the two acts, 50 Act and the 51 Act. It's very like our situation, where they complement each other.
Showing us the 50 Act.
50 Act and the 51 Act.
50 starting is.
দুটো flag করে দিত, flag করে আমি দিয়ে দিই জজ সাহেবকে।
This is 50 Act.
50 and 51, I have made the two flags, my lord. There are two flags.
Yes.
Lord, please see the preamble. Lordship will get the subtle difference between the two. 51 is with regard to the conduct of the elections and the limitation of the different constituencies. Preamble. Statement of objects. Now, Lord, if your Lordships see the compilation, the Lordships will find that they really don't operate in the same field, but in complementary fields, where the 1993 Act, its sole purpose is to set up the commission and give certain powers to the commission. And the powers are only in section 9. Of course, Lord, there is a power in section 11 for review. Or, I'm sorry, revision. but essentially Section 9, and the two powers to act on requests and to hear complaints. So far as the 2012 Act is concerned, they are meant for filling up vacancies in services and for posts, services and posts. And they set down the procedure and the manner in which they are to be done, by what method, what is the formula, etc. The only definition which your lordships may require, insofar as the two acts are concerned, is the definition of lists which are the same in both. And in both, your lordship will find the expression lists is in plural. Yes. See in the first 1993 Act, and so far as the 2012 Act is concerned, they use the expression in F, lists. Same definition. But then, Lord, this leads one to the conclusion that there is a possibility contemplated by the legislature of there being more than one list. Why more than one list? Because Indira Sawhney permits more than one list by way of backward and more backward. Now, Lord, if your lordship comes back to the definition of backward classes, insofar as this 93 Act is concerned, your lordship will find, keeping aside scheduled castes and tribes, as specified by the state government in the lists. So the duty is of the state government. The lordship please takes now the 2012 Act to H. It says other backward classes shall mean such classes of citizens as specified in Schedule 1, other than scheduled castes and scheduled tribes, and include such classes as the state government may by notification in the official gazette specify from time to time. So there is no conflict between Section 9, which gives the powers of the commission to enumerate communities as being backward or not backward, and the power of the state government to make lists as backward and more backward as in Schedule 1. No, there is no conflict and no repugnancy between the two provisions. Now, Lord, is it possible, if I may ask myself the question, for the state government or any other authority having a vested interest to misuse this power? And say now that the 2012 Act has come in, I do not require the umbrella of the commission, the statutory body under the chairmanship of mandatory under the chairmanship of a retired High Court judge, and I can do whatever I want. Which has been the argument that there has been a misuse of power. Lord, in my respectful submission, when your lordships are considering the constitutional validity of a statute, misuse of power is a consideration which will stay at a distance. Which will stay at a distance when a lordship is considering the constitutional validity.
Before you, in aid of this argument that you seek to advance, what is the object and purpose of the 2012 Act? What we wanted to know from the Advocate General, and now that you are advancing arguments in similar lines, can you please elicit before us what, according to you, is the object and purpose of the 2012 Act? Whereas you had the 93 Act, you had the power under 60, not you, I'm saying the state had the power under the Constitution itself under 16(4), and it used that power all the way up to 2011 and 2012 before the Act came to issue orders classified. Why did the state, according to you, Mr. Sen, need this 2012 Act? There must be a reason behind. You don't enact a legislation for the fun of it.
Look, I cannot answer for the state, but if I may address this issue myself from my side, if I may address it in this fashion, is the enactment of such a legislation barred by law? Is there any lack of legislative competence? Is there any prohibition either under Part 3 to come out with such an act? If not, the question of why did the state come out with such a statute becomes more clear.
Objective reason, that's what we want.
Look, the objects and reasons appear from the statute itself. The preamble gives an indication of the objects and reasons.
Now,
The recruitment and fixing up three things. One is with regard to 10%, 7%.
you had that power even before the 2012 Act, which you did also exercise.
We did exercise 100-point roster, all these powers. Now they're enumerated by way of a codification. The state has the power to come out with its own legislation, and it did.
There is no mention of the commission or the role of the commission.
No mention, because no mention is required, because the classes, I'm sorry, I keep on making this mistake. The communities which are classified by us as backward, recommended by us as backward. Now they are being subcategorized into more and less. And different benefits are being given to them.
Of other backward castes or the entire act in any way does not even use the word commission at any point.
It does not. It does not, which is why my only answer to your lordship's question, which your lordships were pleased to ask me a little while back, what role did you have and what role did you play, is that I have no role to play. Therefore, they were not required to consult me.
Subclassification is concerned.
Subclassification.
Classification
Of course.
Under 2012 Act.
Not 20.
The Act does not mention even a comma or a full stop or a single
About the commission.
with regard to the commission's role.
Because
Where does it mention? Does it mention?
No, it does not. It does not. It
So
does
because
not.
the state government and the legislature, first, by the exercise of legislative power, they can straightaway declare a class as backward without reference to the commission.
Look, they
This
can.
is the only conclusion that comes out of it. Number one.
Look, they can.
Number two.
Look, they will have to carry out an identification of backwardness first.
From their own side.
93.
Without involving the commission.
From 93 Act.
No, there's no mention of the 93 Act.
Lord, if your lordship please comes back to the provisions of the definition of other backward classes,
Yes.
shall mean such classes of citizens as specified in Schedule 1, other than scheduled castes and scheduled tribes. Into such classes, state government may by notification in the official gazette specify from time to time.
That's right. Where is the mention of the commission?
Now, Lord, this is with regard to backward or more backward, A or B. Lordship looks at Schedule 1.
Classes of citizens as specified in Schedule 1.
The Lordship has a look at Schedule
So
1
is it an act only for subclassification?
for subcategorization, subclassification,
Not at all for the purpose of classification.
and giving them reservation. Give reservation.
So according to you, this act has got nothing to do with classification.
Look, this is not my understanding is that the identification of backwardness has to be carried out by the commission. Identification of backwardness. Not now whether particular community identified as backward would be classified as more backward or just backward, giving them difference of benefits, one 10%, the other 7%, is the sole repository of the state.
So this act, according to you, deals with the subclassification.
Subclassification.
You will classify.
Not
I mean, you will
I will only carry out identification. Nothing more than
There is
identification.
no role at all of the commission.
I
anywhere. There's no
could not find. I could not find. Because that is why, Lord, I cannot answer anything else except to say that in this we had no role
But
to
there
play.
is mention of lists here and lists
It's
there.
same definition. Same definition, and in plural.
Lists there,
In plural.
lists there already permitted the state to subclassify, and the state did so.
They permitted the state to create lists.
And also the state subclassified before the act came into
The
force.
state's power to subclassify came from Indira Sawhney itself.
That's right.
So now this is only codification of the powers given by Indira Sawhney.
But this act, the act didn't stand in the way of subclassification by the state in 2010, which it did for the first time in September 2010.
Lord, there may be n number of powers conferred by Part 3 of the Constitution. Some of them may be classified by the state for the purpose of recruitment, giving them promotion, giving them benefits, reservations.
The state chose the legislative mode, which is
very appropriate because it streamlines an executive act.
It puts it into a sort of a system,
Codified
codification.
system. And how could you parallelly also confer the same power on the executive?
Now, the power.
Or, which means if it's a classification or subclassification, it has to be placed before the legislature and the amendment is required to be passed.
Now,
parallelly, you are conferring power on the state legislature under the definition of
on the executive.
On the executive, or then and include such classes as the state government by notification, the official gazette.
No, I'm not, in my respectful submission, there is no infirmity in giving power to the executive also.
Parallelly.
Yes, my lord.
What is the, I mean, so here on one end, the legislature
Because
has
they have, either way, they have to satisfy the test of judicial review, either way.
But this power was already there under 16.4.
Power was
So
there under
once
16.4.
From 16.4, the state had the power, exercised the power from 93, even pre-93 Act.
Pre-93, right from the Constitution, 50.
The day Constitution was born, you exercise the power. In 2010, up to 2010, you continue to exercise the power. Classification and subclassification. Suddenly, you wanted to transfer that power in a more codified manner, in a more appropriate manner to the legislature. Very wise. We appreciate that.
And recognize the power of the executive. And also recognize the power of the executive.
This is where the danger lies. Because the power is coextensive. Unless there is a law, the executive does not have the power to frame policy or issue guidelines unless there is delegation of power.
Not unless not the writ petitioners.
Delegation.
No.
This is a parallel.
No, there's no delegation. There is no argument of there being any excessive delegation of essential legislative functions. There is no such argument.
This
is not a delegation. Is not a delegation.
You can, in an emergency, executive power in aid of legislative power is used in emergent situation. 213, you
executive powers can be used even to fill up gaps in legislation.
Dangerous.
Dangerous, but there are innumerable examples where to fill up the gap until the legislature comes out with appropriate rules by regulations, administrative instructions, it can be done.
It is conferred under 213 by an ordinance. Otherwise, to exercise this is uncanonized power, Mr. Sen. What are you saying? You already had the power to divorce the act in 2012. You did not need the 2012 Act to classify.
But why I say this is not uncanonized is because this power already existed.
That you have shifted it to the legislature, and very wisely so. To parallelly again confer it to the executive is what is bothering us. And without any restriction. Legislature may sit, may pass. You may be in majority, you may not be in majority in the legislature.
Not for the executive to notify, it would still have to satisfy the test of it being backward.
That is a different issue. Notified.
Where your lordship is saying untrammeled, then comes in the power, the abuse of power.
Executive
then comes in the question of abuse of power.
Executive has power, consult commission, get their recommendation, issue notification. On the parallelly, legislature also has the power without consulting the commission, no mention of the commission.
Amend the schedule.
Amend the schedule. So are you saying they only have to fall under OBC A, OBC B, or they can be pure OBC?
Under 2012 Act, OBC A.
The three categories.
No, I think there's no B.
No,
OBC A and OBC B. OBC A and OBC B. I'm
It can
sorry.
never be an OBC per se. It has to be A or B.
No, under 93 Act, there will be OBCs.
So there will be a third. So OBC.
OBCs, and that particular community may or may not be subcategorized.
সেটা 93 একটা এটা যেটা উত্তর দিতে পারছে না যে প্যারালাল লেজিসলেশনের দরকার
is basically the classification of the powers of subcategorization which would be
ছেলেগুলোকে এনেছে তখন তো 93 না, সেটাই জজ সাহেব বলছে কেন আবার করতে গেলে ছিল যখন পাওয়ার কেন করতে গেলে আবার
Yes.
Now, Lord, so far as identification of a community as backward, that will be done under a 93 Act upon a request or upon a reference.
12 Act does
Once it does not need to, because it does not go back to that stage.
Legislature is competent
Now, Lord,
to do it.
now, Lord,
Because Indira Sani said either to come by commission or legislation.
now, Lord, 2012 Act enables, Lord, the legislature by way amendment to the schedule or the executive by notification in the official gazette to subcategorize the communities already classed as backward into A or B, and to give the A and B dissimilar benefits by way of reservation to the extent of 10% or 7%, or
under the 93 Act, this OBC definition as goes. This was for the purpose of this act means backward class citizens other than SC, ST as may be specified by this act. Now in the 12 Act comes that what my brother is asking, that under one act you say that yes, they cannot do it without our recommendation. And the further act does not speak about any existence of the commission also.
Lord, it is not for me to say, but perhaps your lordship.
The creature of statute.
I'm the creature of the earlier act, but your lordships may read into it. Lordships may judicially read into it the necessity of the state commission to make the necessary inquiry and recommendation for demarcation.
Not as a lawyer in the commission.
Yes.
Your view is that the OBC definition of OBC must essentially read the role of the commission.
Yes. This is my personal view.
Obviously, as I said, as an officer of the court, not as a lawyer for the commission.
For the purpose of
harmonious concern or contextual reading. Now, please carry on.
Now, Lord, so this, Lord, Lord, a question put in less forensic words: why so many Muslims? Lord, I don't refer to what we have done, but the fact remains that in none of the studies is being Muslim the consideration for being enumerated as backward in the papers which have been handed over to your lordship. It may be accidental or it may be coincidental, or as a matter of fact, some of the communities or the majority of the communities are Muslim. But being a Muslim is not the determinative or even a factor for being classified. So just
Sen,
2-3 paragraphs from Indira Sani in this regard.
Mr. Sen, we have been taken through that. The best argument which has come from the state and which you will also independently argue, which we have indicated that it's only incidental that they happen to. They were backward. Merely because they are Muslim doesn't make them less backward or more backward. They happen to be Muslims. You found them as backward. We are concerned with the methodology you adopted. Please indicate and explain that to us.
No, the methodology is what it is.
What
the
is the
the methodology is on paper.
You have gone to 10 villages. How many persons went to those villages? You have said report of X. We accept this report of so-and-so Chakraborty. Very nice. Did you examine? You had the pass under the of a civil court. Did you examine him on oath? How many places, how many reports, how many members were in part of your survey? What was the number of people who were surveyed? Is this all brought on record? It
Lord,
has not been.
Now, Lord,
We have repeatedly requested you to do so.
Lord, papers have been filed by the state, which reveal the procedure followed for each of the communities, which have been classed as backward. I think they filed a compilation of
Where were the
7.
documents lying? They are supposed to lie in your custody. And I mean, they are your documents.
They
You have
already
produced them.
no, I think they have already been filed. I know.
Yeah,
We have
just circulated.
They've been circulated, not been filed.
We have seen it from at least.
Oh, I was under the impression they have been filed.
From your website.
Lord, may I
What
just
we have found, Mr. Sen, is Indira Sawhney. I mean, logic would have demanded that one doesn't need to go as far as Indira Sawhney. A normal survey, has to cater to address the entire population. One. Two, the number of people, places you have admittedly surveyed, as published on your website, are a few villages. In some districts, in some cases, some families, in some cases, based on the application. Application comes, the man, I don't know whether he was examined or not. Then what is the evidence? So somebody says that, so-and-so community is backward on oath, and that's it. The tribunal will take that as the commission will take that as the gospel truth. No evidence required. We found your client wanting in this area, and seriously so. I mean, apart from the niceties of the 2012 Act and the 93 Act and the legal arguments there, you leave that aside. We are concerned with your commission's role. How did you go on this process of identification? Survey. Were you found so inadequate even by the state that they had to go to the Calcutta University for subclass?
We engaged the Cultural Research Institute, CRI.
You engaged the CRI.
CRI is a state's organization.
Right.
We engaged them. Yes.
This is new.
Isn't it? No, stated organization.
They are a CRI is a weak.
They have been doing this all along, right from the beginning. Right from the beginning. So they were the one who did it.
The commission engaged the CRI.
Lord, whether there was an official appointment to a CRI, I'm to check up. But they carried out the survey. They carried out the survey.
আমাদের এওটা দেখাচ্ছি তোকে
Now, Lord,
এনার এও না
two other things, Lord, I'd like to only show your lordship.
So there must be a resolution, Mr. Sen.
I'm not aware. I have not seen it. I have not seen it, Lord. I have not seen it. Now, Lord, the lordships will take into account the particular class which is shown to your lordship. There could be two ways of doing it. One is to say N block. We find that there is an unscientific temper managed to shroud the entire process of survey. An unscientific temper, as your lordship was kind enough to point out. Or your lordship may take it that the ones which are pointed out to your lordship as not fulfilling the requirements of a proper scientific survey, those are the ones which your lordship will look into. Now, Lord, there is also a power of revision, which is a revision which has to be done every decade. There also the power exists in the commission to carry out a revision of the classes which have been enumerated as backward.
Carry out the last.
No, I don't think it has been carried out, but it can be directed to be carried. There are various ways, Lord. I don't think there has been any revision carried.
The best way, sir. Since 93, we have 2003 and now we are in 2013. 30 years have gone. More than 30 years. one, at least you should have done two by this time. These people once backward occupying government posts to that reservation levels, they must have improved themselves to some extent.
As of now,
You have not chosen to review their classification.
কি বলছিস তো? কি রিভিশন হয়েছিল? রিভিশন হয়েছিল কবে? কবে হয়েছিল? জজ সাহেব জিজ্ঞেস করছে। রিভিশনটা কবে হয়েছিল তাই জজ সাহেবকে বলতে হবে না? জাস্ট কান্ট গিভ
And the consequence and what you did pursuant to the revision. Did you find that even a revision requires a detailed examination?
Absolutely. যদি রিভিশন করেছে কি ফাইন্ডিং এখনো ব্যাকওয়ার্ড my junior tells me that one of the classes was
What was the result of this review? One class removed.
that's what I'm instructed এটা কোন বছরের
Mr. Sen, what we understand from the object and purpose of 11, section 11 of revision is essentially to test whether the representation, given reservation made by you,
whether the
affirmative action has been
fulfilled its
affirmative or
purpose,
not.
whether the affirmative action is fulfilled its purpose or not.
Because if it is not fulfilled its purpose, either it is useless, you have to make an analysis and make a recommendation on that, or for some more time it hasn't served this way, or suggest some other measure. Under 15.4, it is not just jobs, because 15.4 role is also there. So that's where the proportionality test comes in. We are deeply concerned with the role of the commission as to why what was done, why classes were continued to be included. Because at the end of the day, Mr. Sen, you are asking the state to take a hit.
Yes.
It is the state that takes the hit, the well-being of the entire community, the entire population of the state that takes the hit. And that is why 11. And did you perform your job under 11 is what we are asking.
এটা নোটিফিকেশন ইস্যু হয়েছিল কোনো রিভিশন অনার unless we get the notification that's it revision doesn't mean revision Your Lordship, the
My lord, it's a
Please place it now that you've handed it over.
Yes, yes.
Please play. Which part of this
Yes.
would you like to place?
It
Please play.
appears that it's full.
In exercise of the powers conferred by Clause 1 of Article 341 of the Constitution, President, after consultation with the governors and Raj Pramukhs of the states
That time
concerned,
they were there.
yes, 50s.
Some states had Raj Pramukhs.
Because 50 is the Sardar Patel's endeavor was still underway. If please see 3, notwithstanding anything contained in paragraph 2, no person who professes a religion different from the Hindu, the Sikh, or the Buddhist religion shall be deemed to be a member of a scheduled caste. Your Lordship will find that a Muslim is not included here. So, my Lord, one of my submissions is what happens as a matter of practice because of this is the scheduled castes who are to be enumerated as per the schedule to be made, Lord, in terms of the constitution. They are comprising of only the Hindus, Sikhs, and the Buddhists. Lord, so far as the scheduled castes are concerned, that's Article 341. The President would notify the schedule, and they would not include the Muslims at all. So the entire group of economically, socially, educationally backward Muslims, they remain out of the SC and SC.
Them being the largest
One of the answers to why there are so many Muslims who are applying. I'm on applying because only when somebody applies, I consider.
Are you saying under the present schedule of SC and ST, there are no Muslims at all?
Lord,
As on date,
As
in
on
2024, there are no Muslims at all?
Not scheduled tribes is not included here, but so far as scheduled caste is concerned, possibly not.
Caste is something that is only for Hindus. It's only
May not be.
Hindu,
Lord Indira Swami says even other religions have castes.
but in a different way. But caste as it's generally understood in the
The
subcontinent
caste system, the casteism,
is part of Hinduism.
the Hindu
The
history.
as per the Manusmriti. But
Similar, two other judge. May I just give your Lordship the citations of abuse of power would not be a relevant consideration. Lord, I would like to rely on AIR 1962 Supreme Court 316 is a Constitution bench judgment. AIR 1962 Supreme Court 316 paragraph 33. Primarily this judgment, there's also a later judgment, but this actually deals with the entire issue. So they're what? 34. If your Lordships are pleased to take paragraph 34, I've got the AIR. Online আছে?
333.
Paragraph 32?
Paragraph 34, possibly of the SEC online version. Lord, the portion starts with, we are clearly of the opinion.
No, that does not tally. Para 32 begins with the 5th point relates.
No, yeah, it's not this.
It's what is the starting of the paragraph?
Starting cover.
এটা ভুলভাল দেখাচ্ছিস কিছু বস না ইপসিটা প্লিজ বস না If your Lordship takes paragraph 34 and your Lordship takes about 5 or 6 lines from the bottom of paragraph 34, just above the quotation, it starts with, we are clearly of the opinion. Paragraph 34, middle portion of paragraph 34. We are clearly of the opinion, Lordship.
Yes.
We are clearly of the opinion that the argument about the relevance of this matter is incorrect and must be rejected. This court has held in numerous rulings to which it is unnecessary to refer that the possibility of the abuse of the powers under the provisions contained in any statute is no ground for declaring the provision to be unreasonable or void. Commenting on a passage in the judgment of the Court of Appeal of Northern Ireland which stated, if such powers are capable of being exercised reasonably, it is impossible to say that they may not also be exercised unreasonably, and treating this as a ground for holding the statute invalid. Viscount Simons observed in Belfast Corporation, "It appears to me that the short answer to this contention, and I hope its shortness will not be regarded as disrespect, is that the validity of a measure is not to be determined by its application to particular cases. If it is not so exercised, that is, if the powers are abused, it is open to challenge, and there is no need for express provision for its challenge in the statute. The possibility of abuse of a statute otherwise valid does not impart to it any element of invalidity. The converse must also follow, that a statute which is otherwise invalid as being unreasonable cannot be saved by its being administered in a reasonable manner. The constitutional validity of the statute would have to be determined on the basis of its provisions and on the ambit of its operations as reasonably construed. If so judged, it passes the test of reasonableness. Possibility of the powers conferred being improperly used is no ground for pronouncing the law itself invalid, and similarly, if the law properly interpreted and tested in the light of the requirements set out in Part 3 of the Constitution does not pass the test, it cannot be pronounced valid merely because it is administered in a manner which might not conflict with the constitutional requirements."
Three sentences can be uttered insofar as this paragraph is concerned. There is no statute in this country or world that has not been abused. Two, the very fundamental principles of administrative law dealing with uncanalized power, excessive delegation are thrown to the wind by reason of this. Those principles would have to be removed from the law books and the law journals.
This is a constitutional judgment.
Constitution even. And and any event, there is, if there is a inconsistent power, parallel power, which is why
Parallel powers are permissible. Parallel powers are permissible.
not parallel powers in this manner. The fundamental proposition, as Mr. Dotto had argued, executive power is coextensive with legislative power, which essentially means there has to be a law based on which the executive acts and delegates or doesn't delegate, either delegated, whatever. That is the whole context. But if there was a constitutional provision, then you brought it under legislation, then in derogation of the limitations of the Constitution, that is ordinance, time limit, placing before the legislature, having it approved and ratified. In derogation of that, you give parallel powers, unlimited, to the executive. Sometimes it may put a question mark on the legislative power. Sometimes it may, the executive may completely bypass the legislature. It doesn't need the statute. In fact, it did not. So repeatedly, why we were asking Mr. Dotto and you, why did you need the 2012 Act? You subclassified even before the 2012 Act. Percentages, you did not need the statute to determine percentages.
The codification gives certainty.
You did not need a statute to determine it.
Look,
We were wondering seriously whether what was the object.
Look, codification imparts certainty.
Well, those are all very nice. It's better to wear a tie with a jacket or even otherwise, but tie makes it complete. But that doesn't mean without a tie you would be inappropriate.
In many places, yes.
In some places. And alien to this country imposed on us.
Any other judgment?
Look, the other judgment is a follow-up 2015.
Yes, give us.
I'm sorry. 2004, Volume 9, Supreme Court Cases, 580, paragraph 22.
All right. Thank you.
Look, just in case I can trace out any revisions carried out, I'm told there are, but I can't make the submission of knowing it. I'll hand it over to your Lordship.
Pursuant to the revisions, whether you included,
yes,
whether you added, whether you said you continued, this is still backward, there must be some discussion.
But if there is anything, I'll have it handed over to your
Say
lordship.
was possibly not there.
Well, now is the time for me to go to the Ganges and take a dip.
We did that last week.
You know, Mr. Sen Learned, it appearing for the commission has concluded his arguments. Stop. For the commission has. For the OBC commission. But the commission has concluded his arguments. Stop. Let the affidavit in reply filed on behalf of the state to the let the affidavit in opposition filed on behalf of the state to the এটা আগের দিন রেকর্ড করেছে to the report of the respondent numbers 3 to 5 comma as filed comma be kept on record. Stop. Lease the matter for further consideration on.
You can only say this before we rise.
It will be
to whatever extent that you may be, the state may be slightly placated, that to both Indira Sahni and all the judgments thereafter have held that the starting point can be caste and religion.
Yes.
So,
caste may
for
form
you to have started like Muslims were backward at a starting point.
Caste.
At all you did. And we can't hold you wrong. Even starting
Monday.
point end, you say these classes, they incidentally happen to be Muslim.
The caste
that
can
by
form a class.
itself also cannot be unconstitutional per se, unless the methodology or something else is determined.
Caste itself can form a class.
If, however, we find that the methodology is wrong, whether you declare all in the Hindu Brahmins of 77 classes as backward, they'd still be wrong.
On 19th as fixed at 2
We may not take the full time. Whatever reply you want to give, please conclude on the 19th.
Central
But I'll intimate it.
What? Yes.
Next Central Commission.
My lord, subject to what the Central Commission submits, we might want to.
No,
make
they
it.
have a short submission. They won't be
Let
taking
them-
long.
Whatever you want to say, you say. And in the meantime, if you on the based on their affidavit, I mean,
On the
your,
basis.
your
And our
affidavit,
opposition.
you are now you have the time.
We'll take my lord 10 minutes. Nilmado for double.
Definitely, sir.
Where the
Nobody
main
will go
main
unheard.
petitioner
So,
fighting for the
position
procedure in himself. Sir.
My lord, I will sit at 2, my lord. Lordship at 2 p.m.
2 p.m. on 19th.
2 p.m.
19th.